Yes.
May 5 and 26, Your Lordship.
Yes.
Lordship, in this matter, Mr. PJ Sakhya is appearing, Your Lordship, due to his ill health, Your Lordship. He is not able to come, Your Lordship. As well as on the last occasion, the respondents had filed their affidavit. We need to file a reply. So I pray that the matter.
Is there a stay order?
No stay.
No stay.
It-
Okay.
it's- In fact, my lord, I pray Lordship may think about Thursday. Why I'm saying is, my lord, so far as item 26 is concerned, there we have already opened the, my lord, technical with pursuant to the honorable court's order. I'm supposed to place it. On 5 grounds, his case has been rejected. His bid has been rejected.
And he's L2.
Lordship, no, in one, item 1 is L2. There
Yeah.
also, my lord, honorable court allowed us to appoint a financial L2. I want that, my lord, my lord, order from this court so that I can open it in the second case.
When will you file your reply?
Lordship, I pray 2 weeks time, Your Lordship. But
Sir, but why do you want to? Why? It's your case. Why you not in a hurry?
Since there is an urgency, Your Lordship, I understand, Your Lordship, may fix it on Friday, Your Lordship. Yes, Friday or Thursday, my lord. At least item 26.
Okay, Friday. Okay, right.
Come up together, Your Lord.
On the prayer of the counsel for the petitioner, the this matter on then
25, 26.
okay Friday okay. Thursday.
Thursday, my lord.
Thursday. Um, in the meantime, the petitioners may file their affidavit in reply.
Item 27, Milord.
May I just write one thing? The orders dated 18/9, the orders dated 13/8/2024 and 18/9/2024 covers the case of the petitioners. Don't say that. Don't say that. Just leave it. Don't say that.
Milord, I'd like to mention item 27 of today's list, Milord.
27. Yes.
27. That
Yes.
is a contractual agreement. During the agreement, Milord, some new developments taken place before we have come to this honorable court. On 8, this honorable court has given direction to pass a speaking order in relation to our representation. They have, Milord, passed the speaking
Speaking
order,
order.
and also the new tender has been floated, Milord.
Okay. So it's becoming structures.
That's why, Milord, we may be permitted to file a fresh petition.
You see, you
No,
can
no.
always challenge the speaking order. There's no need of permission required.
No, if that matter is listed before your lordship, today was the fixed date for them.
I know.
Yes.
You are seeking extension as a chemist, correct?
No chemist, Milord. It is a medical supply
Authorized.
of medicine to the
Yes.
depot.
So this writ petition has become infructuous if the speaking order has been passed.
The speaking order is defective, Milord. That is why this subsequent
So
development.
you challenge the speaking order if it's defective.
Yes, Milord. That is why we are paying for giving the opportunity of filing this here, Milord.
Where's the question? Show me the speaking order. Show me the speaking order. We will take it up as it comes. Mr. Counsel, will take it up as it comes.
Okay, fine.
May please, Your Lordship. Lordship, I have to mention item 133 to 39, Your Lordship.
Yes.
Here we have to communicate with because new incumbents has come in as the containers, Your Lordship.
Huh?
New incumbents have come in as the containers. We have to communicate them. We have to implement the new.
Yeah, for the petitioner.
Yes, Lordship.
Okay, Mr.
DJ Das, Your Lordship.
DJ Das.
At least 3 weeks time will be granted. Your Lordship.
Huh?
3 weeks time will be granted. In the meantime, we will communicate with the.
Yes, the last time this similar order was passed, allowing you to make the correction.
Lordship, in the meantime, Lordship, it took time to find out the new incumbents, Your Lordship.
Mr. DJ Das is granted 3 weeks time to file an application for impediment of the new incumbents as respondents. This is the matter of the 3 weeks.
Wait, Malab, I am praying for listing of this matter, Malab. We have filed Malab this tender matter, Malab. Malab, we have challenged the NIT, Malab, and NIT is going to open on day after tomorrow, Malab. So, Malab, maybe come up tomorrow, Malab. If your question.
May please your lordship. Item number 40, Milord. Under instructions, I'm not pressing the matter.
Okay. Mr. S. Banik, learned counsel for the petitioner, submits upon instructions that he is not, that he wants to withdraw the writ petition as he does not want to press the matter. And who is appearing for the other side?
Kapil Singh.
Mr. M. Chetty appears for. All respondents. The prayer of Mr. Banik is allowed. Interpretation is dismissed as withdrawn.
What is to the non-payment of contractual fee? The matter was listed on 25/9/2000.
Give a date, 25/9. What in a hurry, madam? Just,
No, my lord, on that day, no notice was issued, my lord.
no notice was issued.
Action to take the instruction to the BTC authority. There, so there may be urgency on my lord.
No urgency, madam. Your contract matter was of which year?
17/18.
17/18. And you filed the writ petition in which year?
One and later one. This is the second time.
Second time it's come. Oh, okay. Next week?
20.
May I please? Sir, I prayed for listing our review application on 23rd Lordship.
23rd.
Yes. Not
I prefer listing of a motion matter, tender matter, my lord, day after tomorrow, 23rd.
I beg to mention,
Is it a new matter?
Yeah, fine.
I beg to mention like contempt matter, madam. Contempt matter.
Yes, what about it?
My lord, regarding the settlement, my lord, what was first part, it was not completed. It was last listed on 3/19/24.
Give a date next week, next month.
May please allow, because I beg to mention item number 8 Lordship. Item number 8 Lordship. Lordship to the engaged council LR Mazumdar is out of restriction Lordship. So kindly adjourn the matter for today Lordship and matter will list after 2 weeks Lordship.
Who is the engaged counsel?
LR Mazumdar.
So he is not here. Adjournment prayer has been made on behalf of Mr. L.R. Mazumdar, learned counsel for the petition. This matter, when?
After 2 weeks.
After 2 weeks. This is a motion matter. For first time it's coming up.
Lordship, he is out of restriction.
Out of station. Where is he gone?
Lordship, he has gone to Mocha for performing Umrah Lordship.
What happened to the police case? What happened to the police case? I think you're running away from this case. Correct? What's happened to the police case?
Lordship,
You've got no idea.
Yes.
Where is this Mr. A. Islam?
Yes, yes.
You are Mr. A. Islam. This is the matter on Friday. This Friday. You get ready this Friday. I'm not leaving this case.
Lordship, Mr. Engaged counsel, LR, he kept filing with him, Lordship.
File is with the engaged counsel. Okay, that's right. The matter pertains to prayer for payment of contractual dues. While the petitioner has apparently, allegedly completed 50% of the contract work. Further, there is a criminal case registered. That is Borkhola PS case number 242 of 2016. Wherein the petitioner appears to be connected. So, this is the matter. After 2 weeks. Heard Mr. M.K. Hussain, learned counsel for the petitioner, who submits that the order dated 7/2/24, passed in WPC 7347 of 2023, has not been complied with, wherein the respondents were directed to demarcate the Garalu Meen Mahal under Moregaon district. Issue notice returnable in 5 weeks. Petitioner to take steps for service of notice upon the respondents by registered post with AD within 2 days, 3 days. List the matter after 5 weeks.
Thank you.
Heard Mr.
T.K. Mishra.
T.K. Mishra, learned counsel for the petitioner, who submits that the order dated 31/5/2015, passed in WPC 7217 of 2023, has not been complied with. Wherein the state respondents, wherein the state respondents were directed to pay the admitted amount of rupees 52,05,289 to the petitioner. Same, issue notice, 3 days. Yes, madam, you take the issue notice. Heard, miss?
Farbin.
Huh?
Farbin.
Louder, madam. Huh?
Farbin Rahman.
You got the name? F. Raman,
That's Rahman.
learned counsel for the petitioner, who submits that the petitioner's contractual dues amounting to rupees 125331 has not been paid. Issue notice returnable in 5 weeks. Miss
Arguably.
R. Gugoi accepts notice on behalf of
1, 2, 4, 5, and 6.
1, 2, 4, 5, and 6. Mr. A. Chaliha accepts notice on behalf of respondent number 3. This is the matter after 5 weeks.
Yeah, it's yours.
Is this a bench 5 matter?
Termination of service.
Termination of service. Is it a bench 5 matter?
Bench.
Bench 3. Bench 3. Mr.
J Mullah,
Mr.
J Mullah,
J. Molla. Out here written M. Molla.
M Mullah.
Huh?
My lord, J Mullah.
Okay, Mr. J. Molla appears for the petitioner, while Miss
ST Buck, Corporation Department.
S.T. Bhatt appears for the Corporation Department. They submit that the matter pertains to bench 3, registry to verify the same and list it before the appropriate bench.
Obligor.
Now, what does he want? What does the petitioner want?
My lord, it's a total case of cost, my lord.
Huh?
Exemplary cost, my lord. The petitioner is not.
The NIT has been cancelled. Now what remains?
My lord, he was lessee in the year of 2021-22.
I know, that's finished.
Now they are claiming the effect of the 29(6) notifications effect, my lord.
I know, they want the daily, they
Yes.
want the daily settlement.
My lord. In both way, they don't have any case.
Right, no one appears for the petition on call. The prayer of the petitioner is to allow the petitioner to operate the TNAGNI weekly open market. On the ground that no regular settlement has been made pursuant to the NIT dated 1/6/2024, which has been cancelled. The petitioner's petitioner's prayer to allow him to operate the market was that he had been the settlement holder for the said market for the financial year 2021-2022, which period has expired 2 years back. There does not appear to be any case in favor of the petitioner. However, as no one appears for the petitioner, it appears that the petitioner is not interested in pursuing the matter. The writ petition is dismissed for non-prosecution. Okay, Mr. S. Datta appears for
PNRD.
penal party. Let him come with a restoration application, then we'll see.
Obligor.
On behalf of SSM, I have received my instruction and file my affidavit. Lots will fix it in next week. There is urgency on the part of the,
When did you file the affidavit? Within,
within this week, lots will fix in the next week.
okay, right. Mr. S. Bora, learned counsel for the respondent,
SSM,
submits that affidavit will be filed within,
this week.
on or
Within a week,
before,
Within a week.
within a week. He prays that the matter may be listed on
30th, my lord.
Huh?
30,
13, 30,
30, my lord.
30. No, not 30.
Let it be on 4th, my lord, Monday, my lord.
Ah.
4th November.
Well, either it could be before 4 days a matter in Supreme Court, or 2 days later,
After
or maybe
4.
on 6th.
Okay, on 6th?
6th.
On 6th. So, what do you want?
My parents consider reported back.
Besides that, do you want to file anything? Nothing. Are you sure? I'm going to record that you're not going to file anything. Madam, if you're going to file affidavit, please file. Otherwise, don't come in on the next date and say that you're not going to file.
There is some urgency in this matter. That is the only issue. We'll file it the affidavit by day after tomorrow, Lordship.
He's saying by 1 week.
No, by day after tomorrow, we'll file it, Lordship. By Wednesday evening, we'll give an advance copy to them. Let them file if any response also. If Lordship is pleased to take up the matter for final disposal Tuesday next. Because very small issue is
No, not Tuesday next. Tuesday next
subject
is
to Lordship's
Tuesday.
convenience at the earliest.
6th, my lord.
Because the money may go back and it is for public interest, Lordship.
If you all, I can do it on. See, I don't want Tuesday, Wednesday because I want it maybe on Friday. I'm ready. Monday, I'm ready.
Yes, on Friday,
Let
Lordship.
it be on Monday, my lord, 28th.
Monday. Okay, so you just say submit that here. No,
Or
you just say
provided they file their reply.
No, we'll file by day
Wednesday,
after
my lord.
tomorrow.
by Wednesday, right?
Wednesday,
Just like
yes.
Mr. D. Sakia, learned AG, submit that he will file affidavit. Submit that the state respondents will file their affidavit in opposition by 23rd.
Lordship.
By 23rd. Full stop. Mr. K. Chaudhary, learner senior counsel for the petition, submit that affidavit in reply, if any, will be filed thereafter by Friday.
By Monday, my lord. Because a client will be from Mumbai, my lord.
Then-
No, my lord, let it be on 28th, we'll file it by 28th.
No, 20th is Monday. No,
28th.
Huh?
28th.
28th. 28th. October 28th.
If they file by,
Again, same thing. I
We'll
thought
file
we'll
it-
have the
we'll file
hearing
it.
on
It's a
Monday.
commitment, Lordship.
no, lordship will have them around 28th.
Okay,
We'll file in the meantime.
but then they will need time to go through it if any.
No, we'll try to file it by, Friday, my lord.
Or you file it by
That's why,
Saturday.
that's why I
Saturday.
was indicating 6th, then it would have been very
They are
convenient.
in a hurry. Is it okay? 6th?
It is good to, we may not like to file also to the response. If required, we'll file. Otherwise, our case is very.
Lordship may keep it for 28th in case of anything.
Okay,
lordship may
list the matter on 20th.
Yes. But the
Miss, where is that item, respond number 6? Miss R.S. Sakia appears on behalf of Mr. S.K. Medi, Land Council for the respond number 6. That's all.
Well, the interim order has to continue.
Interim order to continue till the next day.
Deeply.
Highly obliged.
Out here, same, 6 and 7 are same, I think.
Yes. Yes, your lordship.
In this case also, the interim order will continue.
Same order.
Here, please, your lordship. Lordship, the matter pertains to non-payment of contractual dues, your lordship.
So,
Let the notice go.
notice. Okay. Heard, Miss?
Steve Musahari, your
Huh?
lordship. Steve Musahari, on behalf of NJ Khatamiya, your lordship. Lordship, Mr. NJ,
Your name is not here.
Lordship, Mr. NJ Khatamiya is out of station, your lordship.
Okay, your name is Miss
Steve Musahari.
D. Musahari, appearing on behalf of Mr. N.J. Khatane. Submits that the petitioners have not been paid their contractual due. Issue notice returnable in 4 weeks. Mr.
S. Niyogi.
S. Niyogi.
Niyogi.
Accepts notice on behalf of
All the respondents.
all the respondents. This is the matter after 4 weeks to enable the respondents to obtain instructions and file affidavit if necessary.
There are two other matters.
Which
my
is
lord,
item?
16 and 17.
16 and 17, same order.
Highly obliged.
Obliged. May I please, Lordship? Lordship, matter is regarding non-payment of contractors.
Where is the admission?
He had completed it. Bill is there, lordship.
No, no, you come, you see your annexure. Annexure 4, page 21.
Page 20. Yeah, this is liability statement, lordship.
Where is the statement? This is only a forwarding letter. Where is the statement? Enclosed as above, it says, where is the statement?
This is not in the one.
Where is this is not a liability statement.
But bill is there, lordship.
Huh?
Bill.
Madam, this is a question, this is not a civil suit. This is a writ petition. You have got to give the admission part. Where is the admission? Because you have taken a stand that this is an admitted fact and there is a statement to that effect. Liability statement is there. That is what you have said. But in your writ petition, there is no liability statement. It's like saying you have got an umbrella with you, but when you come before us, you don't have an umbrella. So where is that liability statement? It is not here. So what to do?
File an additional affidavit and keep it on the record.
Miss
Yeah, on the lordship.
Anjana Das,
Yeah.
the Angana, learned counsel for the petitioner. Liability statement, which was supposed to be enclosed with the letter dated 3/12/2020. Bracket annexure 4 of the writ petition. List the matter after.
11 of also lordship have contacted.
11, okay, we'll issue order. Heard Miss Diangana, learned counsel for the petitioner who submits that the petitioner's its contractual dues have not been paid. Issue notice returnable in 5 weeks. Miss,
I did.
accept notice on behalf of
All the rest.
all the respondents. This is the matter after 5 weeks. Heard Mr.
D. Kolita.
D.
Kolita.
Kalita, learned counsel for the petitioner who submits that the petitioner's contractual dues amounting to rupees 599,130 has not been paid. Issue notice returnable in 5 weeks. Miss Udas, accept notice on behalf of respondent number 2. While who accepts? Who is for PWD? Mr. Gogoi, you're there? While Mr. B. Gogoi accepts notice on behalf of respondents number. On behalf of all the other respondents, all the other respondents. This is the matter after 5 weeks to enable the respondents to file their affidavit. We have issued notice, no? No. What is your case, Mr. Counsel?
My lord, 15 time, my lord, non-bailable warrant was issued by the court below, my lord. For my lord, this petitioner, my
So
lord,
why don't you file a what? What is this? Who has filed non-bailable warrant over it?
no. Court, trial court issue, my lord, because.
Criminal court.
Yes.
Criminal court has
Criminal
issued.
court, my lord, maintenance matter, my lord.
Material matter.
Maintenance of wife and my lord, young child, my lord. They have order passed, my lord, 2019. My lord, thereafter, my lord, many occasions, 15 occasions at least, my lord, I have annexed the order sheet. My lord, the OC and SP, my lord, I appreciate SP also filed representation also, they are not executing, my lord, the order. I'm not getting justice, my lord. This lady, my lord, and minor children, my lord.
Otherwise, lordship, the matter is pending with lower court. Lordship.
Huh?
It's before the lordship, SDJM lordship.
But the problem is he's not getting anything. What to do? He has his wits end.
Then lordship. Otherwise, he has to approach
What?
lower court lordship.
Huh?
Since 19, I am approaching. 2019, my lord, I am approaching, my
With
lord.
jurisdiction regarding execution of lordship.
I'm not for
Eh,
execution.
eh, eh,
MBW.
It's a execution of?
MBW lordship.
Where is the question of execution of NBW?
Yes, says that it is not executed by the lordship, the authority of respondent of 4 and 5 lordship.
Not executed by police, my lord, yes.
Where is that order of maintenance?
My
Page?
lord, my lord, maintenance order says 13, my lord. There's the order dated 26/9/2019, my lord.
Page 13.
And my lord, operative person, my lord.
And after that, non-bailable warrant of arrest has been issued to your husband, late husband,
Yes, yes,
or
yes, my lord.
separated husband or what? Or divorce,
Husband, not divorce,
not divorce.
not divorce. My lord, page 19 onward, my lord, page 19 to page 40. All
Now,
are my
now
lord-
what is to be done? What is the procedure? Can you guide the court?
My lord,
If non-bailable warrant 15 times have been issued, nothing has been done. Then now, what is the,
There may be a report before the lordship.
no, is there any bar for him to approach this court?
my lord,
Mr. Saikya, can you help us?
what is my lord, maybe?
What has happened is, his wife and the petitioner is the wife filed a maintenance case. And court has said that give maintenance. I don't know how much, 5,000, 8,000 a month.
3,000 for wife and 1,500 for my lord.
So 4,500 per month
Yes.
for the child. Now the husband is never turning up. The court has issued 15 non-bailable warrants, criminal court. The court. Now they are still not appearing. What is to be done?
Option is for the police to get him arrested now.
So it should, I think, can we issue notice here? In a writ petition?
Let the matter be taken up day after tomorrow. I'll give the complete instructions on this logic, or whatever is the law.
Yes.
Because I have dealt with this kind of matters earlier. It ultimately he has to be arrested and he will not be released from the jail till he pays.
The problem is he's not being arrested. That is why.
Yeah,
it's
that is
coming.
why. The
Now, what is
bounded
to be
duty of
done?
the state lordship.
Huh?
The duty is cast upon the state to
Correct,
get him
correct.
arrested.
Correct,
It is not that just to go and serve it all the
correct,
time.
correct, correct. So why is he not
He
being
will not
arrested?
then he should be picked up and produced before the court by the police. So let me get the instruction. If it is
Okay.
not done by the police intentionally or deliberately, they will have to do it.
Okay, okay.
Right, my lord.
Right, heard Mr.
Yes, Chauhan, my lord.
S. Chauhan, Learned Counsel for the petitioner, who submits that the petitioner had filed a MR case number 396/2018 under section 125 CRPC in the court of the Judicial Magistrate First Class, Hojai. The same was disposed of by final order dated 26/9/19, by which the respondent husband was directed to pay a monthly maintenance amount of rupees 3,000 to the petitioner wife and 1,500 to meet the expenses of the minor child. Full stop. As the petitioner, as the respondent husband was not complying with the order, the petitioner filed what? What did you file?
My lord, file execution petition, my lord.
Filed execution petition case number?
But, the same case, my lord.
Filed an execution petition?
Yes, my lord.
Filed an execution petition for complying with the final order dated 26/9/19 passed in MR case number 396/2018. So next para. The petitioner's grievance is that despite the court of the Judicial Magistrate First Class Hojai having issued approximately 15 non-bailable warrant of arrest against the respondent husband, MD Muhammad Ali, son of LT Abdul Jabbar, resident number 2, Kring Kring, PS Lumding Hojai, page 13. The police have not been able to arrested. That is point number 2 till date. Have not arrested the respondent husband till date. Full stop. Mr. D. Saikya, the learned AG, submits that the matter may be listed on Wednesday, on
Friday.
or Friday, by which date he shall obtain instructions as to why the respondent has not been arrested. List the matter on Friday.
Highly obliged.
Please, your lordship.
Your Lordship, in this matter, we have challenged the two clause of the tender. One, debarring the joint venture from participating, and the other is,
Debarring or not being included, basically. You want
no, what are,
does it say specifically that joint ventures are debarred?
yes, sir, joint venture cannot participate. And the second is that they have sought the experience within the state of Assam.
There's sought experience within the state of
State
Assam.
of Assam. So, Your Lordship, this honorable court was pleased to direct the respondents not to open the bid. Today was the date of the opening. But I wish to inform this court that the petitioners have participated in the tender process.
Then
Nothing,
what remains?
nothing remains. Therefore, that's facts. I was intimidated yesterday night because the
Then
clause which I'm challenging, against that clause, he has participated, sir.
not only that, I find that the petitioner is not a joint venture.
No, the petitioner is not the joint
Then,
venture.
is it your stand that that if you are allowed, you would enter into a partnership with some other person and enter the bid process, the tender
Yes.
process?
Yes, sir.
Is that was that your case? But now you have participated, what do you
Yes,
mean?
Your Lordship. That's, I'm fairly submitting that, Your Lordship.
So at end of the matter. Okay, right. Heard Mr. R. Sinha, learned counsel for the Sinha or Singha,
Singha, SNGH.
GHA, learned counsel for the petitioner, as well as Mr. B.D. Das, learned senior counsel for the respondent,
For respondent number 5 and 6.
correspondent number 5 and 6, assisted by Ms.
RD.
Ardeka. Mr. K. Gogoi appears for 1, 2, 3, 4, and 7. Full stop. Next para. The petitioner's counsel submits that though the petitioner had made a challenge to certain conditions in the NIT dated 23/9/2024, and though this court had given an interim order on 8/10/2024 that the technical bid should not be opened today, comma. The petitioner's counsel submits that the petitioner has participated in the tender process by submitting his bid document, his tender document. That he accordingly submits that the said action of the petitioner has resulted in the petition becoming infructuous. Full stop. In view of the submission made by the petitioner's counsel, the writ petition dismissed as infructuous.
Interim order also goes, Madam.
Do I have to say that? No. You see, once we start saying that,
Yeah,
then expect it everything.
It's all right.
Leave the word.
May it please your lordship. This petition is filed by the petitioner against against respondent number 2, who floated the tender for item of dry erase writing boards, approximately 64,945 number of whiteboards, Your Honor. Your Honor, the petitioner has duly submitted all the required documents relevant. And on 27/8/2024, the respondent number 2 has disqualified the petitioner,
Why, on what ground?
stating that the average annual turnover was not submitted and past experience documents were required.
Let us see which page.
Your Honor, page number 37, annexure number 4.
Page number 37,
Annexure number 4. Your Honor,
annexure 4, yes.
yes, the comment section.
The bidder has not uploaded OEM annual average turnover,
Yes, lordship, and
past experience.
past experience section.
Now, where does it say in the tender notice that these are required?
Your Honor, the tender notice is filed on
Where is the term and condition in the tender notice which says that these two requirements have to be submitted?
Your Honor, in bid document, page number 31, document required from seller,
Page 31.
page 31.
Yes,
Experience criteria, bidder turnover certificate, OEM annual turnover, etc. It is a 2-packet bid system, lordship. technical and financial. In the technical round, we are disqualified. However,
So if you have not submitted these documents, so what is wrong?
we have challenged it. We have challenged it.
So you have challenged what?
We have challenged this order by submitting the required documents. And
Oh,
again,
no. One thing. When was the last date of submission of documents?
document submission that is not available.
It must be in the tender notice. Here, you see, bid end date time, page 31, 2/7/2024. That is the last date. The first column. Bid end date time, 2/7/2024. So this is the last date for submitting your tender document.
The
Okay.
opening date is also the same date.
Correct. That is usually what happens. This is your first time doing our contract work.
Right.
That's why. Usually it happens on the date, the last date, say at 1 o'clock or 2 o'clock it closes, and the many instances that on that date itself, in the evening, it's open. So the last date is 2/7/2024. Now, this document by which your bid has been cancelled is of 27/8/2024.
24.
Correct?
Right, Lordship.
Now, this says that you did not submit your annual average turnover and past experience. When did you submit those documents?
Those documents we submitted after this rejection.
After this letter,
Yes.
end of the matter. You have to submit it on the last date of submission of tender. So there are two options. Either you withdraw or you have to dismiss. Otherwise, there's no other, unless you can show me a third option.
Annexure 40, Annexure 7, page number 40.
40.
Honor, after we have submitted these documents, there is an arbitrary order, Your Honor, Lordship. Page number 40. Again, response, after we have submitted these documents, the response came from the respondent number 2 is that the documents submitted by you are not called by the buyer.
I do not know what documents you submitted, but first of all, you have got to cross the first hurdle. The first hurdle is, did you submit your OEM annual average turnover as required in the tender conditions? And did you submit any documents regarding your past experience?
We have submitted.
Within time, did you submit within time? Not after the last date?
If the validity period is 180 days,
Yes.
Validity period of the bid, Lordship, that is not basic ground, Lordship. Lordship may come to page 10, paragraph 9. Lordship, the OEM.
Paragraph 9.
Yes, Lordship, that is, he do not fulfill the criteria, and that is why he failed to submit.
Paragraph 9.
Paragraph 9, the further OEM average
Then the
turnover.
further the OEM had demanded by respondent number 2 was rupees for the past.
He participated, but he failed to furnish this document, Lord, because he do not fulfill that criteria. So even if he is given an opportunity now to furnish his documents, Lord, he will not.
Okay,
be-
so he said that the past experience, the turnover demanded was 400% of the estimated amount.
If that is the objection, Lord, if he should have filed before participating.
Is this your case?
that is also a ground, Your Lordship. And
But that is not the ground for, that is not the ground for of rejection.
Full submission, Lordship, on
Huh?
the day when the technical bid was opened, those required documents were not furnished.
Correct, that's all.
That is the only issue.
Now, even if this new ground is taken by you, prima facie, even this court finds that, okay, this should not have been there. 400% no one demands. But then you have not put this to challenge. You should at all.
Lordship, the submission made by me, these documents were, we are given opportunity to submit further these documents, Your Lordship.
No. Where have you been given? No.
No, it's a
When you have been,
no question
we have
of giving
challenged.
opportunity.
you see, Mr. Counsel, when your bid has been rejected on that ground, where's the question of giving you opportunity for submission at a later date? Show me that document where they have given you opportunity to submit.
Challenge documents are submitted, Your Lordship, page number 38.
You submitted, when did you submit? You said those documents?
That is.
You don't know the date, but after this rejection. End of the matter, Mr. Counsel. You have to always be very careful On the last date of submission of your tender, all your documents have to be there. Right. Heard, Mr.
H. Talukdar.
H. Talukdar, learned counsel for the petitioner. Also heard Mr. P. Nayak, learned counsel for
Respond number two.
respond number
SSC.
2. Who is for Secretary, the Department of Education? While Mr. R. Mazumdar appears for respondent number 1. Is there a council? Is there a council out there? No, it's not wearing band or anything. Then next time better to wear a black necktie or something that looks. Okay, right. The grievance of the petitioner is that his bid, technical bid or what? Is it a 2-bid system or 1-bid?
Bid system.
Is that his technical bid was disqualified by the respondent authorities on 27/8/2024, as the petitioner had not submitted OEM annual average turnover. Had not submitted, has not uploaded OEM annual average turnover. Which covered approximately 400% of the estimated bid value. That is his case. No, that is, otherwise it says not covered. No, it is here, not covered, is here. It's here.
Rejection was not before the authority till the date of his rejection now. It is in the petition only.
No, it's okay. We'll put that. But this has to be construed in that light, I think. And I had also not submitted documents regarding his past experience. So, sir, the petitioner's counsel submits that as per the GM rules, part 2, clause 9, bracket 1, the bidder's average annual turnover requirement cannot exceed 40% of the estimated bid value. And the requirement of the bidder to upload 400% of the bid value was illegal. He, however, submits that the petitioner submitted the required documents after he was informed of the disqualification of his technical bid on 27/8/2024. Next paragraph. Mr. P. Nayak, the learned counsel for the respondent number 2 submits that the petitioner should have made a challenge to the requirement of a bidder requiring to submit 400% of the estimated bid value in the OEM annual average turnover required to be submitted by the bidder.
One. Secondly, Lordship, page 31. Lordship, may kindly come to the that bigger row, Lordship,
Yes,
towards the end. Documents required from seller.
yes.
Experience criteria, this is, Lordship, may kindly see in the second line, OEM annual turnover.
Correct.
So this is the mandatory.
Correct.
condition.
He submits that as the petitioner had not submitted the required document as required in the NIT. There was no infirmity in the rejection of the petitioner's technical bid. Accordingly submits that the petition should be discussed. Next paragraph. I have heard the learned counsel for the party. The NIT. No, this, the respondent number 2 had floated bid number GM/2024/B/503/8093 dated 12/6/2024, calling for the supply of 64,945 dry erase ERASE writing boards by way of a 2-bit system bracket technical and financial bracket close, by floating the same on the government e-marketplace bracket GEM platform. Good stuff. The NIT stated that the last date of submission, the last date and time for submission of the bid of the tenderers was 2/7/24 at 2 p.m. The petitioner apparently did not submit the OM and annual average turnover or the past experience documents required in terms of the NIT, due to which the petitioner's technical bid was rejected on 27/8/2024. Full stop. Next para. The NIT, the bid documents required to be submitted by a bidder in terms of the NIT is reflected in the bid document chart, which states as follows. You take this page 31. I put it in blue, huh? Second last, third last. The petitioner had apparently submitted the required OEM annual average turnover and past experience only after the rejection of his technical bid was made known to him, was communicated to him. As the petitioner's technical bid was not complete in terms of the requirements of the NIT, this court does not find any infirmity in the rejection of the petitioner's technical bid. The writ petition is accordingly dismissed. Heard Mr. L. Mohan, learned counsel for the petitioner, who submits that the petitioner's vehicle hire charges amounting to rupees 47,99,840 has not been paid. Issue notice returnable in 5 weeks. Mr. K. Gogoi accepts notice on behalf of all the respondents. List the matter after 5 weeks to enable the respondents counsel to obtain instructions and file affidavit if necessary. Huh?
Treatment of party item 19.
Deputy Commissioner Lordship, Boyangao and Lordship necessary to party.
Okay, heard Mr. S. Hawk, learned counsel for the application, who submits that the District Commissioner, Bongaigaon, should be implemented as respondent number 8. Ms. R. Dekha, appearing for the Water Resource Department, submits that she has got no objection to this. Accordingly, the District Commissioner, Bongaigaon, is implemented as respondent number 8. The applicant should submit a corrected cost title in the writ petition before the registry within a week. Within a week.
Lordship, tomorrow I can give tomorrow, Lordship.
Okay, within 2 days. Within 2 daes. Then the IA is accordingly allowed and disposed of. Then in the main writ petition, you write, in view of the order dated 21/10/2024, passed in IAC 2902 of 2024, the district commissioner Bogaigaon is impeded as respondent number 6.
Eight.
Issue notice to the respondent number 6. Who will accept?
8 lordship. Just for 8 only.
Respondent number 8, sorry, respondent number 8. Who will accept? Mr. M. Chetty accepts notice on behalf of respondent number 8. List the matter. When?
After 2 lordship.
Okay, Mr. M. Chetty shall obtain instructions from respondent number 8 and file affidavit within 3 weeks. List the matter after 3 weeks. Extra copies of the writ petition be provided by the petitioner's counsel, Mr. S. Hawk, to Mr. M. Chetty during the course of the day,
Yes, lordship.
or within 2 days,
Yes, by tomorrow I'll do.
within 2 days.
Okay.
Maybe the lordship, I believe on the last date, wrong orders were sent up. So this honorable court had ordered for the correct LCR to be called for.
My lord, I am for the respondent number 3. My senior is not feeling well today.
Not an issue.
Okay, right. Adjournment prayer has been made on behalf of Mr. A. Das Gupta, learned senior counsel for the respondents. Accordingly, leave this matter after 3 weeks.
You want? APO.
This case, the respondents were supposed to file the affidavit.
Yes, say the affidavit.
Our written instructions we have not received yet. lordship.
You have not received what?
Any written instruction.
Okay, Mr.
I got
I bought a court learned counsel for the forest department, PHE,
PH.
PHE. Is granted another 4 weeks time to obtain instructions and file affidavit. This is the matter of the 4 weeks.
Okay.
Regarding non-payment of admitted contextual amount, they're supposed to obtain instruction. Otherwise, what is the completed certificate?
Who is the respondent number 4? Health department?
Not related to health.
NHF is not a party to this. They've got nothing to do with this case. So who is for the health department?
The other day they appeared, man, it took time to obtain instruction.
Mr. P. Naik was there, no, they did not appear. Health department did not appear. Acha, it says here, yes, appeared, but the name is not reflected. So what to do?
Let the matter be listed there for tomorrow, lordship. They will appear. Or maybe after some time, lordship.
Okay, tell him to appear.
Yes. In this matter, on the last occasion, it was the consensus was arrived at that instead of taking up the IA, the main matter may be taken up. The pleadings are complete. Matter pertains to blacklisting, madam.
Blacklisting.
The facts are like this. There was an NIT issued.
NIT dated
NIT was dated 12/9/2019
12/9/19.
for gas compression services. And this particular tender pertains to operation and maintenance of South Bansakandi gas compression services for a period of 3 years. Now, if your lordship will kindly turn to the petitioner was shortlisted and awarded the contract. If your lordship will kindly turn to the agreement, page 25. Your lordship will first have page 32. I'm just placing the relevant clauses. Page 32 is the duration of the contract, clause 3.0. The
Page
contract shall-
32 duration, yes.
3.0.
Ah,
The contract shall be for a period of 3 years from the date of mobilization of complete set of equipment and personnel at so and so. although this agreement is dated 16/10/2019, the period of the contract was subsequently extended. Your lordship may just make a note of the date. It was valid till 9/11/23. After the extension, the
Hmm.
validity was to expire on 9/11/23. The next relevant clause, your lordship will find it page 42. Under the contract, the contractor was supposed to employ people on contractual basis. And the contractor was supposed to provide for insurance cover. This is provided at page 42, clause 60. 16 capital A, contractor shall at his own expense arrange workmen's compensation employer's liability insurance policy to cover statutory liability of an employer for the workman engaged under this contract, also to cover all risks assumed by the contractor in respect of his personnel deputed under this contract. Now, the next relevant clause is at clause C, subclause C. Certificate of insurance. Before commencing performance of the contract, contractor shall upon request furnish the corporation with certificates of insurance indicating kinds and amounts of insurance as required herein. 2, insurance corporation or companies carrying the aforesaid coverage. 3, effective and expiry dates of the policies. 4, that corporation shall be given 30 days written advance notice of any material change in the policy. 5, waiver of subrogation. Endorsement has been attached to all policies. And 6, the territorial limits of the policies. And next portion is important. If any of the above policy expire or are cancelled during the term of this contract and contractor fails for any reason to renew such policies, then the corporation may replace the same and charge the cost thereof to the contractor. Next, should there be lapse in any insurance required to be carried out by contractor hereunder for any reason, losses resulting therefrom shall be the sole to the sole account of the contractor. So if there is any lapse or any loss on account of lapse of a policy, insurance policy, whatever losses are to be recovered from the contractor. So the consequence of lapse, etc., is given. Now,
No, it
there-
shall be the sole account, doesn't say recover. Where do you get the word recover?
basically what it says, the contractor will be responsible for it.
That's what, there's no question of recover. But it can,
Essentially, that is what
it'll, but because that will amount to saying, pay first and recover from it. That, because it basically says the contractor will
in a
be
nutshell,
solely.
the financial liability will be borne by the contractor.
Yes.
Now, there is another provision at page 91 regarding insurance. Page 91, this is continuation of the agreement itself. At the very top, your lordship will find the heading note, and under that, clause 6.
Yes.
Clause 6, the wages to be followed shall be as per applicable oil gas industry standards, but not limited to applicable oil gas industry standards or ONGC's fair wage policy. Note on fair wage policy. Up to the fourth line, it talks about wages, which you are not really concerned with. Up to the
Yes.
sixth line.
Ah.
In the seventh line, towards the right-hand side, your lordship will find a sentence starting in addition to the.
Yes.
In addition to the above, they will also obtain group insurance cover from
Who will
LIC.
obtain? They will also obtain, who will
The
obtain?
contractor.
Contractor.
They will also obtain group insurance cover from LIC from individual benefits of rupees 5 lakhs in case of death, group accident insurance cover from any GIC for individual benefits of 5 lakhs, and group gratuity policy, etc., from LIC meeting the statutory obligation. So this is an additional requirement of for insurance. Now, your lordship will kindly turn to page 44. This is also relevant for the case.
Page 44.
Page 40. Clause 18 provides for termination of the contract, the circumstances in which a contract will be terminated. 18.1, termination on expiry of the contract. This agreement shall be deemed to have been automatically terminated on the expiry of the contract unless the ONGC has exercised its option to extend this contract in accordance with the provisions, if any, of this contract. Thereafter, clause 18.2 is termination on account of force majeure. Then termination on account of insolvency. Then termination for unsatisfactory performance. Then termination for delay in mobilization. So these are the other situations in which termination can take place. Now 18.6 is relevant.
Yes.
Your Lordship may kindly mark the heading, consequences of termination. So when a termination takes place under 18.1 to 18.5, these are the consequences that will entail. In all cases of termination herein set forth, the obligation of the ONGC to pay shall be limited to the period up to the date of termination. Notwithstanding the termination of the agreement, the parties shall continue to be bound by the provisions of the agreement that reasonably requires our action or forbearance after such termination. Next one. In case of termination of contract herein set forth, except under 18.1 and 18.2, your Lordship will kindly note this one. So the consequences, for further consequences, except in case of 18.1, which is termination on expiry, and 18.2, termination on account of force majeure. Annulment of the contract due to submission of performance security as per clause 36 of annexure 1 of tender document, following action shall be taken against the contractor. ONGC, subclause 1. ONGC shall conduct an inquiry against the contractor, and consequent to the conclusion of the inquiry, it is found that the fault is on the part of the contractor, then they shall be put on holiday. This, they call it putting on holiday for blacklisting. That is, neither any tender inquiry will be issued to such contractor by ONGC against any type of tender, nor their offer will be considered by ONGC against any ongoing tenders where the contract between the ONGC and that particular contractor as a bidder has not been concluded for a period of 2 years from the date the order of for putting the contractor on holidays issued. So, as a consequence of termination, except 18.1 and 18.2, they can also blacklist the person. Now, there is another provision for blacklisting that your Lordship will find. There is an integrity pact that we were required to sign when. So that your Lordship will find at page 108.
Yes.
So this is the integrity pact that we have signed. And if your Lordship kindly turns the page to page 109.
Yes.
Under section 3, right in the middle of the page.
Yes.
Page 109, section 3. Disqualification from tender process and exclusion for future from future contract. If the bidder before contract award has committed a transgression through a violation
Before,
of
if the bidder before contract award has committed. What do you mean? Before contract award has been committed.
If during the tender process, if he has committed any
Okay, and before the contract is awarded.
Has committed a transgression through, this is very important, through a violation of section 2. So this has to be before the contract is awarded, and it is in case of violation of section 2. I'll come to section 2 a little later on. Or in any other form, such as to put his reliability or credibility as bidder into question, the principal is entitled to disqualify the bidder from the tender process or to terminate the contract if already signed for such reason. Next, subclause 1. If the bidder contractor has committed a transgression through a violation of section 2, such as to put his reliability or credibility into question, the principal is entitled also to exclude the bidder contractor from future contract award processes. The imposition and duration of the exclusion will be determined by the severity of the transgression. So even in this case, the extent has to be decided on the basis of the severity. Now, the next sentence is equally important. The severity will be determined by the circumstances of the case, in particular, the number of transgressions, the position of the transgressions, within the company hierarchy of the bidder and the amount of damage. The exclusion will be imposed for a minimum of 6 months and maximum of 3 years. Next, a transgression is considered to have occurred if the principal, after due consideration of the available evidence, concludes that no reasonable doubt is possible. So, firstly, this has to be in violation of section 2. Secondly, even assuming it is in violation of section 2, the severity is one of the factors to be taken note of. And the third is that there is no reasonable doubt. Now, that takes us back to section 2. So what are the violations that section 2 talks about?
Yeah.
If your lordship comes back to page 108, your lordship will find section 2 towards the bottom. Commitments of the bidder contractor. The bidder contractor commits itself to take all measures necessary to prevent corruption. He commits himself to observe the following principles during his participation in the tender process and during the contract execution. The bidder contractor will not directly or through any other person or firm offer, promise, or give to any of the principal's employees involved in the tender process or the execution of the contract, or to any third person any material or immaterial benefit which she is not legally entitled to, in order to obtain in exchange any advantage of any kind whatsoever during the tender process or during the execution of the contract. That is the first.
Just a minute, will not directly. Okay, yes.
Basically, this is to prevent bribery. Then the bidder contractor will not enter with other bidders into any undisclosed agreement or understanding, whether formal or informal. This applies in particular to prices, specifications, certifications, subsidiary contracts, submission or non-submission of bids, or any other actions to restrict competitiveness or to introduce cartelization in the bidding process. Next, the bidder contractor will not commit any offense under the relevant anti-corruption laws of India. Further, the bidder contractor will not use impropriety for the purpose of competition or personal gain, or pass on to others any information or document provided by the principal as part of the business relationship regarding plans, technical proposals, and business details, including information contained. Excuse me. Next, 4, the bidder contractor will, when presenting his bid, disclose any and all payments he has made and is committed to or intends to make to agents, brokers, or any other intermediaries in connection with the award of the contract. Now, these are the relevant clauses. Now, coming to the facts of this particular.
The bidder contractor will, when presenting his bid, disclose any and all payments he has made. Yes.
Now, coming to the facts of this particular contract, this case, what had happened was, the company is located in Mumbai. So we were getting our insurance done from Mumbai. The employees that we had employed, since this is in Silchar, the employees, they wrote a letter to us, which your lordship will find at page 112. And
Yes.
actually, page 112.
Yes.
This is written by the employees employed by the contractor. As per the above mentioned subject, we would like to request you to manage and arrange our medical group insurance from our hometown, that is from Silchar, Kachar, Assam. So we may coordinate and process our requirements with the local office of the concerned insurance agency and along with the concerned representative too. Also, we would like to share that last insurance was carried out from the Mumbai office. For that, we had faced lots of problems regarding the correspondence with the concerned representative and insurance company at Mumbai. For that, we had faced delay in overall processing and many more other issues. Thus, we are requesting you to arrange the above mentioned from a local town, that is from Silchar, Assam, so that we can manage the above mentioned smoothly and resolve many other hidden problems in the coming time. So this, based on this request, we said, all right, you do it from Silchar. We entrusted one of these employees that you get it done from Silchar itself. Now, he gets it done and he sends us a digital copy. That your lordship will find at 113. The contract, the earlier insurance was supposed to expire on 31st of October, 2021.
Early insurance,
Was
Yeah.
supposed to expire on 31st of October, 2021. So when this employee sends us this new policy, we find page 113. This is the digital copy that was sent to us.
letter dated?
No, this is the policy itself, insurance policy itself.
Yes, whatever, digital copy of the policy dated.
Policy date is. What does it? A collection date towards the left hand side, your lordship will find. That will perhaps indicate the
Okay, anyway, it is for the period from 1/11.
1/11/21 to 31/10/22. So we at Mumbai received this and we are under a bona fide belief that it has actually been done. It has been renewed. Now, the ONGC authorities wrote a letter to us, which your lordship will find at page 127. I'm not troubling your lordship with the whole contents. They, in essence, they asked for a physical copy of the policy. So when the ONGC authorities asked for a physical copy, we in turn asked from the employee the copy, physical copy. And when the physical copy was received by us, that your lordship will find at page 132.
When did ONGC ask you for a physical copy?
This was on 20th of June. Key date was it? Page second line, 20th June.
20th June.
20th June.
And then your letter to the. and
No,
then-
but first, when we in turn asked for the physical copy,
Yeah.
this physical copy you also will find at page 128. And your lordship will find that the period is from 2/12 instead of 1/11. So there effectively was a gap of almost about a month.
No.
Yeah.
There was a gap of more than a year.
No,
The earlier digital copy received by you
no,
was
I'm
from
sorry, madam.
1/11/21 to 31/10/22.
No,
You come to page 113,
that is the earlier policy, madam.
correct?
No. The
Okay, so that policy was there.
that-
So
that-
that 1/11/21 to 31/10/22, that is a valid policy?
No, I'm sorry, my lord. Your lordship will first come to page 113.
Yeah.
This was the earlier policy with regard to which there is no dispute.
Okay, no dispute. Okay.
Now, the disputed one is at page 122.
122. Oh, this you did not take me through this.
I'm sorry. The disputed one is at page 122.
122 is from
1/11/22
1/11/22 to
31/10/23.
31/10/23. Okay.
Now, the physical copy is at page 128. And your lordship will find that it starts from the validity period starts from 2/12/22,
2/12/22 to
1/12/23.
1/12/20.
So
Okay, so there is a gap of around 2 months.
30
2
days.
months. 2 months. 2
No.
months. Huh? 2 months.
1/11.
Okay, 1 month. 1 month.
1 month.
1 month.
So as soon as it came to our notice, this physical copy we received, we wrote to the ONGC authorities, which your lordship will find at page 140.
Yes, then what happened?
With reference to your mail asking for the hard copy of the insurance policy, when we obtained it from site, we have observed a difference in the dates with the soft copy submitted. In the soft copy, it was 1/11/22 to 31/10/23, as we received from the site by mail. But when we obtained it now from the site, it is 2/12/22 to 1/12/23. Even though the policy submitted is real, the actual effective dates are with a gap of 1 month. We are attaching here with the copy of the original one, along with this letter. However, the original copy shall be physically delivered to your office. In connection with this, we'd like to inform you certain matters. Usually all the insurance policies are opened and managed centralized from our head office at Mumbai. In this contract also, first year it was done from the head office itself. But when the second year renewal time, employees of Silchar requested us to open the policy at Silchar, saying that it will be easier for them to get the claim if it is opened at Silchar itself. Considering their request, we allowed them to open the policy at Silchar, and it was opened and managed at Silchar itself. Despite this, there was a claim issue of one of our employees. The entire claim amount was paid by Spectron, that is the petitioner, irrespective of the insurance claim limit. Details of the claim and payment receipt certified by the employee is attached herewith. Now we come to know that the claim issue was due to the difference in the date, that is the policy was renewed at site by the site employees later than the actual date it was supposed to be done. We are going to initiate an inquiry into this matter. We would like to inform you that even though a delay occurred in renewal of the policy by the site staff, neither any of the employees were affected nor any revenue loss or claim on ONGC has happened in this regard. We clarify the position that this is what has happened. Now they, after a long delay, 22nd of June, we wrote to them. They issue a show cause notice to us at page 141.
Yes.
On 5/10/2023. You are hereby required to show cause in writing within 15 days from the date hereof as to why business dealing with your firm should not be placed in the banning list and be debarred from entering into any contracts with ONGC for the following reasons. With reference to the contract mentioned above, you had submitted an insurance policy bearing number so-and-so with collection date 12/10/22 and the policy date effective from 1/11/22 and valid up to midnight 31/10/23. Later on, you had submitted another insurance policy bearing the same number but with a different collection date dated 2/12/22 and policy effective from 2/12/22 valid up to 1/12/23, both being from the same insurer, that is Star Group Health Insurance. With reference to contract clause number 36 of page 28, submission of all documents, this is a violation of the terms and conditions of the agreement. As per note 6 of the of Annexure C, it is provided that as part of fair wage policy, you are required to provide ESI mediclaim coverage as applicable for all employees and their dependents deputed for execution of the aforementioned job as per the agreement for the whole period of execution of the contract. However, it appears that there has been a period starting from 1/11/22 to 1/12/22, wherein there existed no mediclaim coverage for the employees deputed at site, which is a violation of the terms of the agreement. Your reply, if any, should be supported, etc., etc. But to this, we responded. Page 143. We gave a detailed reply narrating these circumstances. Page 143. With reference to your show cause notice dated 5th October 23, received in our office on 11th October 23, please note our reply on 2 points as advised by our legal advisors, so and so. In the above letter, you have mentioned to show cause that why business dealing with your firm shall not be placed in the banning list and be debarred from entering into any contracts with ONGC, wherein we would like to mention that in your contract page number 28, clause 36, submission of forged documents as per the said clause, ONGC has clearly mentioned that forged documents, certificates, information submitted towards fulfillment of any of the tender contract conditions. ONGC shall immediately reject the bid of such bidders or cancel, terminate the contract and forfeit so and so submitted by the bidder. Once the contract is signed, the word banning is not a part of the contract. Therefore, we would like to mention that banning is nowhere mentioned in the contract document. You can penalize us in terms of financial deduction. However, signing the contract banning will not be justified since it is not the part of the contract. Moreover, we'd also like to mention that we have been running the contract for 3 years and it is almost in completion stage of the contract period. And this particular issue was not brought to us earlier. Mentioning of the banning word itself is shocking to us since this is not a part of the signed contract as per the above clauses. However, this was not in the knowledge of the company management. This minor modification of the insurance document was done by one of our contractual employees, which was not in the approval of the management of our organization. We'd also like to highlight that we have been successfully managing the project without any default or production revenue loss for ONGC. We have successfully completed the project without any issues. As per your letter point number 2, you have mentioned about Annexure C. It is provided that as part of fair wage policy, mediclaim coverage, etc., etc. In the effect of that, we would like to mention that it was entirely the responsibility of Spectron engineers, wherein we have met all the requirement of our staff so far, which will fulfill till the end of the contract. During the lapse of the insurance, there was a claim from one of the staff, and the entire claim amount has been reimbursed to the concerned person. We have not put ONGC responsible for any claim made by our staff. As per contract, page number 16, clause 16C, it also clearly mentions that any claim from our staff is the sole responsibility of the contractor. Over and above, we would also like to mention that we have several persons working in different locations of the country. If some of the persons make such negligent act without the knowledge of the organization, wherein you cannot penalize the contractor, whereas if you feel we have terminated, suspend such persons or any other mode of penalties. As per our company practice, we have been making the policy from our head office. However, in this particular project, staff had requested for the policy to be made from local organization for the convenience of claiming the amount faster, against which we are enclosing the letter received from our staff for your reference. As you are aware that our company has been giving services to oil and gas sector for more than 2.5 decades, wherein we have not defaulted or done any modification in submission of documents. We have been always working towards the satisfaction of the client. Based on all the above and also as per contract page number so-and-so clause number 36, it is evident that once the contract awarded, then there is nowhere it is mentioned that you can ban the contractor since the contractor is performing the services to the satisfaction. However, this clause clearly mentions that you can penalize the contractor in terms of financial deduction. As per Annexure C policy responsibility is concerned, the contract page number 16, clause number so-and-so, very clearly mentions that all responsibility of insurance claim will be the sole responsibility of the contractor. What we are essentially saying is there might have been a lapse, but the consequence thereof is already given, that it will be the responsibility of the contractor, which we have already fulfilled. So, and as I was pointing out from the termination clause, that it is only as a consequence of termination under 18.3 to 18.5 that blacklisting can take place. And none of these have occurred. However, my lord, based on these same grounds as mentioned in the show cause notice, they issued the impugned order of blacklisting that your lordship will find at page 149. And your lordship will find very interestingly, page 150.
Yes.
The basic fact is mentioned in the first paragraph itself. They themselves admit that the contract had already expired. In the first paragraph, your lordship towards the end will find contract validity was up to 9/11/23, and your lordship will kindly note the date of the impugned order. It's exactly 2 months later. So they completely overlooked. There was total non-application of mine to the fact that the contract had already expired under 18(1). And once having expired, it was expressly excluded. Blacklisting was expressly excluded in the contract. itself.
Impugned orders at which page?
Page 150. 150. Whereas so-and-so was awarded a contract, so-and-so for maintenance, operation and maintenance of so-and-so, dated 12/9/2019, and contract signed on 16/10/2019 by the amendment number so-and-so to the contract. Due date of mobilization was extended from 3/7/2020 to 10/11/2020 without levy of LD due to force majeure, because COVID had intervened. The contractor mobilized their resources on 10/11/2020, and accordingly, the contract validity was up to 9/11/2023. So they are themselves accepting the fact that contract had expired under clause 18(1). Next, and whereas during the course of execution of the contract towards mandatory requirement under note 6 of annexure C of the contract to provide ESI mediclaim coverage for all employees and their dependents, contractor submitted a group insurance number so-and-so. They are narrating the fact. Then paragraph 3, whereas upon inquiry with the insurance policy, Star Health, etc., the said group insurance policy was confirmed to be valid from 2/12/22 to 1/12/23 instead of 1/11/22 to 31/10/23 as named by you. Thus, there was a period of 31 days so-and-so when no insurance was enforced, and prima facie a case of submitting fake forged documents was made out against you for covering up the aforementioned deficit. This allegation does not find place in the show cause. In the impugned order, for the first time, they are coming up with this. And they also, at para 7, your lordship will find a mention of a report, purported report. At paragraph 7, they are talking about a report. We have categorically stated that this report was never furnished to us. It was a statement to us. Paragraph 13. Paragraph 13. What was it? What was it? Of affidavit. In our affidavit in reply, paragraph 8, no pagination analysis. The lordship will kindly come to page 250. Page 252.
Yes.
That it is paragraph 8, that it is pertinent to mention that a show cause notice dated so-and-so was issued to the petitioner number 1 company on behalf of ONGC by the general manager. pertaining to an inquiry which was to be conducted into the allegations against it. Pursuant to such show cause notice, an inquiry was conducted behind the back of the petitioners, and on the basis of such report, which was never furnished to the petitioners, the impugn order dated so and so was passed by the authority. Now, the challenge that we have made the contentions are, my lord, firstly, blacklisting is permissible under two clauses of the agreement. It is under 18.6, where it is only as a consequence of termination under 18.3 to 18.5, and 18.1 is expressly excluded.
Only as a consequence of terminating the contract.
The second power that was available to them was in terms of the integrity pact. And that integrity pact again expressly says that such kind of blacklisting can be done only in case of violation of Section 2. And in this particular case, Section 2 is not attracted in any manner at all. Now, the other aspects are the ones that flow from the, because your lordship is aware, the law relating to blacklisting is a judicially evolved law. Your lordship, I'll quickly place the main judgment, Eurasian equipment. The extreme civil consequences that befall on a person blacklisted was emphasized in Eurasian equipments for the first time. And that citation is 1975, Volume 1 SCC, page 70. And
Page
I'm not
70.
troubling your lordship with the entire judgment. I'll just place paragraph 70.
Yes.
In fact, well, I'll quickly place a few lines from paragraph 12 also. If your lordship will first come to paragraph 12, just a few lines, the extreme consequences that befall. Towards the middle, your lordship will find a sentence starting, the government cannot choose to exclude persons by discrimination. Towards the middle of paragraph 12. Line about on 11th line from top, my lord, paragraph 12. Sentence starting in the middle. The government cannot choose.
Well, where are you giving me?
Eurasian equipment. 70.
No, okay. Yeah.
It is 75, 1 SCC
Yes, yes.
7. Para 12 towards the middle.
Yes,
The government cannot choose to exclude, as my lord got.
yes.
The government cannot choose to exclude persons by discrimination. The order of blacklisting has the effect of depriving a person of equality of opportunity in the matter of public contract. A person who is on the approved list is unable to enter into advantageous relations with the government because of the order of blacklisting. A person who has been dealing with the government in the matter of sale and purchase of materials has a legitimate interest or expectation. When the state acts to the prejudice of a person, it has to be supported by legality. Now, coming to paragraph 17.
Yes.
The government is a government of laws and not of men. It is true that neither the petitioner nor the respondent has any right to enter into a contract, but they are entitled to equal treatment with others who offer tender or quotations for the purchase of the goods. This privilege arises because it is the government which is trading with the public, and the democratic form of government demands equality and absence of arbitrariness and discrimination in such transactions. Hofield treats privileges as a form of liberty as opposed to a duty. The activities of the government have a public element, and therefore there should be fairness and equality. The state need not enter into any contract with anyone, but if it does so, it must be so fairly, without discrimination and without unfair procedure. Reputation is a part of person's character and personality. Blacklisting tarnishes one's reputation. So this is the extreme consequence that follows. Now, the next judgment out 2014. Your Lordship, I think I had the occasion to place this judgment in connection with another blacklisting matter before Your Lordship. This is that Gorkha Securities case. 2014, volume 9 SCC 105. Here, paragraphs, the paragraphs that I'm relying on are 16, 21. This is for two different reasons, madam. 16 and 21 is for a different purpose, and 24 to 26 is for a different purpose. 16 and 21 effectively lays down that the charges should be very clearly set out, and the precise nature of the penalty proposed to be imposed also should be clearly set out in the show cause notice itself. Para 16, it is a common case of the parties that the blacklisting has to be preceded by show cause notice. This was laid down in Eurasian itself. Now, the further development. Law in this regard is firmly grounded and does not.
Is it your case that in the show cause notice, nothing was mentioned that they would be blacklisted?
No, it was mentioned, but the forgery is a new element that was brought in later. So, paragraph 16 and 21. In fact, the reason I'm placing paragraph 16 is the apex code in Eurasian equipments, it said that only reputation gets started. Here, the apex code has termed it as a civil death in paragraph 16. So I won't trouble your lordship with 16, but what 21 says is important one. The central issue, however, pertains to the requirement of stating the action which is proposed to be taken. The fundamental purpose behind this serving of the show cause notice is to make the noticee understand the precise case set up against him which he has to meet. Now, 24 to 26 are for a different reason, madam. Here also, like in the present case, assuming they can be considered to have the power, although they do not. Our first point is that they do not have the power under the contract. Assuming they have, their own integrity pact says that you have to base it on objective material, the severity of the transgression, the extent of damage caused to the organization that is owing this. All these aspects have to be gone into. And even thereafter, what are the possible penalties that you can impose? You have to apply your mind to that also. Now, in paragraph 24 to 26, this is exactly what had happened in Gorkha Security Services. If your lordship will kindly come to paragraph 24. Here also there were multiple options. They did not apply their mind to the options. It would be necessary to take note of the relevant portion of clause 27 of the NIT, under which umbrage is taken by the respondents to justify their action and even appeal to the High Court. Clause 27A reads as under. In case the contractor fails to commence execute the work as stipulated in the agreement or unsatisfactory performance, or does not meet the statutory requirements of the contract, department reserves the right to impose the penalty as detailed below. 20% of cost of order agreement per week up to 2 weeks delay. After 2 weeks delay, principal employer reserves the right to cancel the contract and withhold the agreement and get this job carried out preferably from other contractors registered with DGR and then from open market or with other agencies. If BGR registered agencies are not in a position to provide such contractor, the difference, if any, will be recovered from the defaulter contractor and also shall be blacklisted for a period of 4 years from participating in such type of tender, and his money may also be forfeited, if so warranted. Paragraph 25. It is clear from the reading of the aforesaid clause that when there is a failure on the part of the contractor to comply with the express terms of the contract and obligor to commit breach of the said terms, resulting into failure to commence execute the work as stipulated in the agreement, or giving the performance that does not meet the statutory requirements of the contract, the department has a right to impose various kinds of penalties as provided in the aforesaid clause. These penalties are of the following nature. Those clauses are repeated, madam. And then in this context, para 26. Para 26 says that you have to apply your mind as to what is the extent of the transgression, and based on that, out of the various penalties, various options available, which penalty you will impose. Now, my lord, the last judgment, this is an alternative argument that I'm making, my lord.
Carry on.
This is an alternative submission. Assuming for a moment we concede that they could have blacklisted. One thing that the Supreme Court has conclusively laid down is regarding the proportionality of the penalty. They had the option of putting some minor financial penalty on us. Why not that? Why go to the extreme of blacklisting? That has been laid down in Kulja Industries case. This is also 2014. 2014, volume 14 SCC 731. And I'm relying on paragraphs 17, 19, and 17, 19, and 20. So basically, paragraphs 17 and 20 lays down that the doctrine of proportionality has to be applied. Para 17. That apart, the power to blacklist the contractor, whether the contract to be for supply of material or equipment or for the execution of any other work whatsoever, is in our opinion inherent in the party allotting the contract. There is no need for any such power being specifically conferred by statute or reserved by the contractor. This is because blacklisting simply signifies a business decision by which the party affected by the breach decides not to enter into any contractual relationship with the party committing the breach. Between two private parties, the right to take any such decision is absolute and untrammeled by any constraints whatsoever. The freedom to contract or not to contract is unqualified in the case of private party. But any such decision is subject to judicial review when the same is taken by the state or any of its instrumentalities. This implies that any such decision will be open to scrutiny not only on the touchstone of the principles of natural justice, but also on the doctrine of proportionality. So this is what I'm relying. A fair hearing to the party being blacklisted thus becomes an essential precondition for a proper exercise of the power, and a valid order of blacklisting made pursuant thereto. The order itself being reasonable, fair, and proportionate to the gravity of the offense is similarly examinable by the court. And in paragraph 19, by relying on several judgments, the apex court says that even the second facet of the scrutiny which the blacklisting order must suffer is no longer re integra. The decisions of this court in so-and-so, so-and-so, so-and-so have ruled against arbitrariness and discrimination in every matter, and is subject to the judicial review before a writ court exercising powers under Article 226 or 32 of the Constitution. Next, paragraph 20. This again talks about proportion. It is also well settled that even though the right of the writ petitioner is in the nature of contractual right, the manner, the method, and the motive behind the decision of the authority whether or not to enter into a contract is subject to judicial review on the touchstone of fairness, relevance, natural justice, non-discrimination, equality, and proportionality. So therefore, my lord, in my humble submission, at the cost of repetition. Firstly, the power itself was not available, as is evident from the impugned order itself. It is 2 months after the expiry of the contract under 18(1). So this was very consciously, the authorities are the authors of the contract agreement. They have very consciously excluded it. So therefore, this power was not at all available to you. And even assuming by some stretch of imagination, we can concede that power. None of these doctrines have been, judicially evolved doctrines have been followed. So therefore, in my respectful submission, this is, your lordships will interfere and strike down the in order of practice. The lordship will just excuse me for 2 minutes. Yes. Facts are more or less clear, lordship. But only thing is that if fraud has been committed and they are trying to dilute the whole situation, they are trying to trivialize the whole issue. Had there been a case, lordship, that the person against whom they are now attributing the fault, whether they have lost any FIR or something like that, if they are really serious, and insurance policy has been manipulated, and as employer, lordship, we trust everybody. It is our duty. But when the document itself, how it has come into light, because they have submitted that insurance policy, these are all stated in our affidavit, we cross-check, we send it to the Star Insurance Company to verify whether that is a genuine policy or not. Then it has come to our knowledge from their response that the date has been manipulated. And in the meantime, there is a claim also. That claim was also not settled by the insurance company. It was settled by them. If at that point of time, they would have come to us and said that our person who is responsible for making the policy has done a mistake or mischief. So it has not come from their side, lordship. It was known to them. And they cannot say that the person in Silchar is not responsible for the activities of the company. Whether it is from Bombay, Delhi, or from Silchar, the person who is doing this, he belongs to the company, and vicarious liability falls always on them. So now coming to what my learned friend was submitting. Assuming we accept everything, that under clause 18.6, we have no authority. Under the Integrity Pact also, we have no authority. Whether as an employer, we can sit idle, that when a fraud has been committed, we are handicapped from taking any action. Because the law is well settled. Fraud vitiates everything. That is the settled principle of law. What they are saying, lordship, that yes, something wrong was done. And what we are saying on the same incident, that it is a fraud committed on ONGC by a contractor. X has done it, Y has done it. We are not concerned about that.
So are you trying to say
I am not saying.
that section 18, anything to say regarding section 18?
Let us go to that, lordship, once more from our perspective. First, let us go to Integrated Pact, lordship. Page 28, lordship will kindly see. Now it is hereby agreed to by the and between the parties in this contract, words expression have the same meaning as are respectfully assigned to them in a general condition of
Which
contract.
page, which page?
Page 28 of the writ petition.
28.
8. It's a part of the contract agreement. Page 28.
28, yes. Now it's here, yes.
Yes. Lordship will see B.
Ah.
The following documents annexed herewith shall be taken as mutually explanatory of one another and shall be deemed to form and read and constitute as integral part of this contract. And in case of any discrepancy, conflict, dispute, they shall be referred to in order of priority as cited below. So one is that Integrity Pact. Annexer 3, page 108, Lordship will kindly come. So their whole contention is that section 2, which talks about corruption, is not covered here. So when we go to section 3, disqualification from tender process and exclusion from future contract. If the bidder before contract award has committed a transgression through a violation of section 2 or in any other form, such as to put his reliability or credibility as bidder in question, in the principal is entitled to disqualify the bidder from the tender process or terminate the contract if already signed for such season. Lordship will kindly see section 2 or in any other form. So when we see any other form, in that situation, Lordship, the priority will definitely be given, can be given to fraud also. 2. If the bidder contractor has committed a transgression through a violation of section 2, such as to put his reliability or credibility into question, the principal is entitled also to exclude the bidder contractor from future contracts and award processes. The imposition and duration of the exclusion will be determined by the severity of the transgression. The severity will be determined by the circumstances of the case, in particular, the number of transgressions, the position of the transgression within the company hierarchy of the bidder, and the amount to be of the damage. The exclusion will be imposed for a minimum of 6 months and maximum of 3 years. So what we have done here, Lordship, we have taken it to be 1 year. We could have gone up to 3 years.
Okay, so under section 3,
3.
under 3(1), it can go up to 6 months and minimum
6 months, up to 3 years. In fact, we are very lenient to them. In fact, a criminal case should have been lost by ONGC at the relevant point of time. When a fraud of this nature has been done, and they have manipulated the document of an insurance company, Lordship. It is not a minor offense. It is a major offense. Till now, they are very lucky that a proper criminal prosecution has not been initiated. So here, in any other form, will cover fraud, Lordship. That is my submission. And now coming to 18.2. 18.2, Lordship will find that.
18, page 30.
Page 44.
44.
Here, we are not on termination. Because when this process was initiated by issuing the so-called notice, the inquiry had taken place. They were seeking time.
So 18 doesn't come into
This
picture.
termination, this is totally redundant in our
So
case.
14 doesn't come.
18 doesn't come, Lord.
So your case is basically 108.
Integrated part,
109.
integrated pact, number 1. And number 2, Lordship, we have another manual which governs our system. That is called, that we have annexed in our reply. Lordship will kindly come to page number of my page, it will be page 216, paragraph 4. That the answering respondent states that the inquiry officer on 30/10/2023 duly submitted its inquiry report to the management of ONGC. In the inquiry report, the inquiry officer concluded that the petitioner has committed a breach, transgression of clause 17.5.1.f of Integrated Material Management Manual and the terms and conditions of the contract agreement by submitting manipulated, illegally altered document during the execution of the agreement, and as such, duly proposed to put up the petitioner on holiday for a maximum period of 1 year from the date of issuance of this binding order. So we have annexed this copy of clause 17.5.1.f of IMMM. That Lordship will find at page 244. That governs us, Lordship. That is beyond the contract. So vendor banning.
Page 274.
244. clause 17.5 says vendor banning, 17.5.1 says removal from the approved list. The name of the contractor may be removed from the approved list of contractors by the enlisting authority if 5 Lordship has indulged in any type of forgery or falsification of records. This is our case. He has falsified the records by manipulating the date of coverage of the insurance policy by 31 days.
Now,
And also L,
uh,
fraudulent activity. So this governs us because that contract agreement has binded him for that particular contract work. Beyond that also this will govern us. And Lordship, his own employee has given that apology letter. Lordship will find that during the inquiry, these documents has come up to us, 2 page 233. The letter issued by one Mridul Subra De, SCPL Silchar. Why I'm showing this document? Because this left nothing for going further in the inquiry. This is a clincher. To the CMD, Spectrum Engineer, kind attention, OK Varghese. Apology for manipulating dates in the Star Health Group Insurance Policy number so-and-so, effective from 2nd of December 2022 to 1st of November 20. There is a mistake here again also. With reference to the above, I would like to inform you that it was absolutely my mistake that renewal of the health insurance was not done on time. And out of here, I did not inform you this at that time, thinking of losing my job. So I manipulated the dates for smooth running of the project. Sir, I never imagined that this act lead to such a major issue and receiving a so-called notice from ONGC mentioning the process of banning the company. I have done this policy from filter only with the request of the other associate staff for their convenience of claim. However, manipulating the dates in the health insurance policy becomes a big issue for the company and is entirely mistake of myself. I have been very sincere to the company all the years looking after the project smoothly. However, this is a big mistake which caused inconvenience to Spectrum. You can take any action on me. I will willingly accept it. Thanking you for giving. Now my question is whether they have taken any action against him, whether they have lost their affair against this gentleman. So they are hand in glove, everyone. And he was working for that company, and whatever is done by him, the whole company will have to take the responsibility.
liable for the acts of the employee.
Absolutely. This is the vicarious liability. The principles are very well laid. So now they cannot say that it was a minor mistake of one of the employees whom they are now trying to outcast when the difficult times come. This is the attitude of the company. Now, coming to the so-cause notice, Lordship. Let us go. Because they have not challenged the so-cause notice. And Lordship has rightly pointed out whether they are aggrieved by the so-cause notice. The prayer is only to set aside the impugned order by which they were put on holidays for 1 year, which is going to be over by January this year. The so-cause notice, Lordship will find 141. Fifth of October 2023, we issued this. So we have very clearly said in the first paragraph, you are hereby required to show cause in writing within 15 days from the date hereof as to why business dealing with your firm should not be placed in the banning list. So we have at the very outset, we have made out, it is very clear to them that what proposed action we are contemplating. And debarred from entering into any contract with ONGC for the following reasons. You had submitted an insurance policy dated so-and-so, etc. I'm skipping. Later on, you had submitted another insurance policy bearing the same number but with a different collection date that is on 2nd of December 2022, and the policy effective from 22nd December 2022, valid up to 1st December 2023, both being from the same insurer, that is Star Group Health Insurance. With reference to contract clause 36 of page 28, submission of force document is a violation in terms of the conditions of the agreement. If they submit false documents, we can always terminate. But the only thing here is that could not be done because the contract was expiring at that point of time. That is why the impugned order was, as my learned friend was rightly saying, it was issued after 2 months of expiry. So what action we can take thereafter? Then we'll have to definitely go beyond the scope of the contract, which he is privy to. But we have certain rules and regulations governing our institution. As employer, lordship, we have certain additional rights. We are not penalizing him for the work or under the contract which he has executed, but under the other guidelines and other principles which governs ONGC. We can always think about somebody has given us false document, and because of the time, it was expiring. If it is in the first year, second year, or in the middle of the third year also, things would have been different. He would have come under 18(6). But this situation is different, but that has not made ONGC helpless. And on top of that, the principle is very clear. If a fraud has been committed, you have to face the consequence. And we are within our limits. That he is getting only 1 year. And on top of that, he's not facing any criminal prosecution. As per note 6 of the Annexure C, it is provided that as part of fair wage policy, you are required to provide ESI Mediclaim coverage as applicable for all employees and their dependents deputed for execution of the aforementioned job as per the agreement for the whole period of execution of the contract. However, it appears that there has been a period starting from 1st November 2022 till 1st December 2022, wherein there existed no Mediclaim coverage for the employees deputed at site, which is a violation of the terms of the agreement. Your reply should be supported by documents and documentary evidence, which you should be rely in support of your, which you wish to rely in support of your reply. Should you fail to reply to this so-called notice within the time manner aforesaid, you will be presumed to have nothing to say and we shall proceed accordingly. Your reply, if any, and documentary evidence given in support of, shall be taken into consideration prior to arriving at a decision. Although he has taken one of the ground in these pleadings that no oral hearing was given, that is not been submitted, so I am not on that. Because oral hearing in this situation is not required.
He also said that with regard to that forged document manipulation, that is not in the show cause notice.
What we have said, clause number 1, page. You have submitted the insurance policy, so and so, so and so. Later on, you had submitted another policy bearing the same number. Everything, only the dates are different. And how he has dealt with it. Along with that letter from his officer, who is posted in Silchar, that I have committed a mistake. Out of fear, I missed the date of insurance renewal. So I have manipulated. What more is required? He has come to know what exactly is the allegation against him. The company knew that the allegation is that there was 2 points are there. One is that for 31 days, there was no medical claim coverage. And number 2, there is a manipulation of the date. And what we are intending to do, if you fail to satisfy us with proper evidence and proper records, you will be banned. In the very first outset, we have indicated that a so cause does not require any further things, Lordship, in my humble submission. The Supreme Court has well given the parameters which on the basis of which a so cause notice, and he has already submitted to the so cause notice. He has replied. Initially, he saw times on 2 occasions, seeking additional time to take legal advice, etc. Finally, he has responded, and in his response, Lordship will see reply to so cause page 143. In the above letter, second paragraph, I am reading. May I read from first? With reference to your so cause notice dated so and so received on 11th October please note our reply on 2 points as advised by our legal advisors. So they take legal advice. And for that, they were given additional time also. In the above letter, you have mentioned to show cause why business dealings with your firm shall not be placed in the banning list and be debarred from entering into any contract with ONGC, wherein we would like to mention that in your contract, page number 28, clause 36, submission of forged documents as per the said clause, ONGC has clearly mentioned that forged documents, certificates, information submitted towards fulfillment of any of the tender contract conditions, ONGC shall immediately reject the bid of such bidders or cancel, terminate the contract and forfeit EMD as if submitted by the bidder. Once a contract is signed, the word banning is not a part of the contract. Therefore, we would like to mention that banning is nowhere mentioned in the contract document. You can penalize us in terms of financial deductions. However, after signing the contract, banning will not be justified since it is not a part of the contract. Moreover, we'd like to mention that we have been running the contract for 3 years and it is almost in completion stage of contract period, and this particular issue was not brought to us earlier. Mentioning of the banning word itself is shocking to us since this is not a part of the signed contract as per the above clauses. Pausing here for a moment, they have done this mischief or this fraud at the fag end of their contract period, not in the first. Had it been in the earlier, the SOCOs would have gone before. So the cause of action has to be arisen to issue a SOCOs notice.
So the only, now the issue.
And
as
we have to
per-
verify it from the insurance company also.
As per section 3,
Yes,
so, transgression, action can be taken when there is transgression and violation of section 2 or in any other form.
any other form.
Now, so this any other form will include,
Fraud also.
and, the only issue is whether this will pertain only to the contract period or it can be acted upon even after the contract has expired.
Yes, for that, our this manual will cover. Then,
Manual.
yes, banning of vendors, 17.5.1.f,
Page 240.
244, if I'm not wrong, Lordship. 244. Vendor banning. It's a very voluminous, so we have annexed the relevant portion of the here. This is beyond the contract agreement, Lordship. I do agree. This is not within the contract agreement, but we have to also follow certain principles.
So this 17.5.1.f.
F and L.
But then this action has been taken under only, I think, F, no?
F, although, but L is also their fraudulent activity. But F is very specific, has indulged in any type of forgery or falsification of records. It is a clear case of falsification of records.
Has this been mentioned in your thing?
So notice.
No, show cause notice is not.
We have
no.
not mentioned.
In the order, it is there, in the main order.
In the main order, Lordship, I'll go a little bit later, Lordship.
Page 150.
150. Whether we have mentioned it or not, Lordship, that will not make the order invalid in my humble submission. But what we have considered here,
No, because if you are going to act upon 17.5.1
Yes, Lord.
F, then you have to at least you put it to his notice under the show cause notice.
here we have not mentioned about any provisions. It is here purely a case of fraud. Suppose Lordship 17.5 is not there also. They have done this kind of criminal offense against us. For that purpose, only he could got the benefit because the contract period was over.
Okay, in that case, in the contract agreement signed between you two,
Yes, Lordship.
was this IMMM mentioned in the contract agreement
IMMM 17.
17? If not 17, even that IMMM, if that is mentioned,
Right.
then it will cover.
May I place this into order now?
Yes, page 150.
Before that, the reply. Page 143, Lordship.
Yes.
Yeah. Moreover, we'd like to mention that we have been running the contract for 3 years and it is almost in completion stage of contract period. And this particular issue was not brought to us earlier. Mentioning the banning word itself is shocking to us since this is not a part of the signed contract as per the above clauses. However, this was not in the knowledge of the company's management. This minor modification, they are privileging the whole issue. This minor modification of the insurance document was done by one of our contractual employee, which was not in the approval of the management of our organization. This, in my humble opinion, is not acceptable at all. The company's policy and etc. It is not given to contractual employee.
No, when they have allowed the contractual employee to do it,
He is
They-
also under a contract.
then they cannot
Short of-
say,
yes.
yeah, they cannot
Yes.
disown the action of that employee.
We'd also like to highlight that we have been successfully managing this project without any default or production revenue loss to ONGC. We have successfully completed the project without any issue. As per your later point, you have mentioned that annexure seat is provided as a fair wage policy. This is not very, then coming to what they are trying to justify is that they are paying for the person who is suffering and who was supposed to get benefit of the insurance policy, but as the policy was not there, the contractor paid it. So that cannot be a ground logic. So they are basically repeating the same thing in the. Now let us look at the impute order. Subject banning of business dealings with so and so involved in the capacity for a period of 1 year. Whereas ONGC Silchar, these are the narration of the facts, 1, 2, 3, 4. Number 4, Lordship will kindly say. Whereas for conducting impartial and independent inquiry in accordance with ONGC rules and regulations, as well as the law of the land. So now we are going beyond the Lordship, the contract agreement. When this inquiry was being done, and whereas for conducting impartial and independent inquiry in accordance with ONGC rules and regulations, that what I have said 17.5, it's a part of the ONGC's rules and regulations, Lord, which governs ONGC. But whether it will cover them or not, that Lordship will definitely have to look into. But my submission is that as institution, we are also governed by certain rules and regulations, whether there is a contractor or no contractor. But if the procedure for inquiry is given under the rules, we have to follow that procedure. And that has precisely been done because the contract agreement does not lay down the procedure. So whereas for conducting impartial and independent inquiry in accordance with ONGC rules and regulations, as well as law of the land, competent authority of ONGC appointed Sri Swarnadeep Das, GM in charge, Infocom, ONGC Silchar, as an inquiry officer in the case. And whereas a notice bearing so-and-so dated 5th of October 2023 was served upon you by the inquiry officer via registered post to show cause why business dealings with you should not be banned, debarring you from entering into any contract with ONGC for submission of course documents. You were asked to reply with all relevant facts and supporting documents to the inquiry officer within 15 days of the issuance of so cause notice, failing which it will be deemed to you have no explanation to offer, and ONGC will take further action as it deems appropriate. Subsequently, considering your email request dated 19/10/2023 for extension of time for submission of reply to so cause notice dated 30th of days, an extension of 7 days was granted to you. Whereas in your response letter dated 26/10/2023, you had accepted that you have submitted manipulated documents against insurance policy, which is in contravention of the insurance policy as per contract. They have directly admitted that we have committed a mistake. Now the issue is whether this penalty is proper it is whether it is proportionate to the offense.
The problem is the show cause notice was issued within time, during the termination time,
Yes,
before the contract was completed. Only problem is the
termination. We did not
impugned,
terminate
that,
because
no,
by lapse of time, it
lapse
got
of time, yes.
terminated.
The impugned order has been issued after the contract expired, after they completed the contract.
Yes, Lord.
That has put a slight spanner in the work. And another thing they're saying is that the inquiry report
Was
has
not
not,
furnished to them.
yes,
That I have a judgment straight away.
okay.
Because what prejudice has been caused? The whole
When
allegation,
they have admitted to the,
yes, but not furnishing. What we are taking into consideration, the whole allegation is one, date of the contract period. And they answer, yes, our office, one of our officers at Silchar has manipulated it. What further remains? It is not a mechanical thing, Lordship, that every situation they have to get everything, but they have not asked for it also. Another pleaded case was that oral hearing was not done. That is also not required, Lordship, in case of fraud.
correct.
And whereas the inquiry officer in its report concluded that submitting forged fake documents and contract to the contractor Spectrum has committed a breach, transgression and terms and conditions of the contract by submitting, this is barred by the contract agreement, Lordship, that they cannot submit forged documents. That is there. Manipulated, illegally altered documents, that is insurance policy schedule, accordingly recommended banning of for all future business dealings for a maximum period of 1 year. And whereas competent authority of ONGC, after giving impartial, prudent and careful consideration of all the aspects of the case, accepted the recommendation of the inquiry officer and approved banning of your firm, Spectrum Engineering, and your allied concerns firm, etc., involved in the capacity for a period of 1 year from the date of issue of this banning order dated till 8th of January 2025. Now, therefore, ONGC has decided to ban any/all further business dealings with Spectrum, along with its allied concern, etc. For that is the same thing, repetition. So, we have not quoted either any clauses of the contract or any clauses of the manual. What we have said that ONGC rules and regulations are being followed, as well as the law of the land are being followed. It is an open and sub case in my humble submission, Lordship. Allegation is very severe, very serious. It is a criminal offense. All the harsh punishment under the IPC or now the present BNS will come here. It is not a case that, Lordship, for just a document has been forged. They have forged a document of another insurance company and they have submitted it to us, a public sector government organization, just for his benefit. It's not a matter of whether it is for 1 month manipulation or 2 months
I think
manipulation.
the issue lies in a very small compass.
Absolutely, very small.
No,
compass.
one thing is whether this section 3 at 109, page 109, this disqualification from exclusion from future contracts,
Lord,
this can be made applicable when a contract is concluded. That is the only point that has to be decided.
now this contract is concluded, that chapter is over,
Correct.
but he has done a offense in that during his contract period, but the penalty which is being imposed upon him
Yeah,
has
yeah,
no bearing on this contract
but you are imposing the penalty
for a future contract.
on the basis of 17.5 that was
Absolutely,
that
Lordship.
under IMM.
Exactly, Lordship.
You are not imposing it under section
We are
3.
not touching all this. We are not touching. We agree to his submission. Because the period is
So
already
the only issue is whether that IMM,
But
IMMM
under if-
will be applicable or
yes,
not. That's
here, Lordship, one more thing. Suppose we have done it under this contract agreement. What we could have done, we could have forfeited his security money or earnest money. That provision is there. But we are going beyond that.
No, because I was thinking, if this section 3, 109,
That also
Whether-
gives us future banning. It is not that this is alien to the contractor. That banning word is not there.
no,
This is
no, I want to be very clear in
Lord.
your submissions. First of all, 18 does not come into the picture according to you.
Yes, Lord.
Section 3 also is not being applied by you.
I
You,
can
you,
say, Lord, I can say it can be applied because we have not indicated section 3 or 17.5. We have not, in our affidavit, we have disclosed everything. In our affidavit, our stand is very clear regarding integrative pact. Section 3, we have taken.
no, but your affidavit says,
Our affidavit very clearly says, I'll take your lordship.
page 216.
I'll take your lordship. Integrative pact is there. We have taken very specific. There are two affidavits. The first affidavit, think the first. I'm not changing my stand. Only my argument's sake is that even if we skip, assuming section 3 as well as 18.6 is not applicable, then 17.5 come. Our affidavit, our stand is very clear. 17.5.1 F plus section 3 of the integrity pact. Very specific stand.
Yes,
Lordship will kindly. Why I'm taking it to them. Then, very long affidavit, the first affidavit. I have written at a market.
A lot of money must be involved.
Yes. Even we are taking, because the person who has filed a writ petition, he does not have the locus also. The proper procedure was also not followed. That paragraph 6, that stand. Plus this. So I am not arguing on those hyper technicalities. Yes. Paragraph 17. of
Yes,
Page 180.
Paragraph 180.
180.
My very long paragraphs. My
Very, very long, Lordship. I stopped reading it, Lordship, at one point of time today. But I have marked it. Paragraph 17, page 17 for a moment, Lordship will
Yes.
kindly see. 175, this paragraph last part before on top of 15. However, the question is to be determined is not as to whether respondent ONGC had suffered any loss or not, because their contention is that we have not suffered any loss. Now, what is our point of view? However, the question that is to be determined is not as to whether respondent ONGC had suffered any loss or not. Rather, the question to be decided is whether the petitioner, in spite of knowing that there is a lapse in the insurance policy, deliberately manufactured and forged documents, policy papers, and submitted the same before the respondent ONGC, and upon granting an opportunity of submission of reply and on due considerations of the materials on record, the petitioner number 1 was blacklisted for a period of 1 year, whether such blacklisting was arbitrary or not. That is the issue. Whether suffering loss or not, that is not the issue. Now coming to page 180, paragraph 17. The answering deponent states that a perusal of the contract agreement in question, more particularly page 28 of the writ petition, would fortify that the fact that the integrity pact also forms a part of the contract agreement. It is pertinent to mention herein that the aforesaid aspect of the matter is further fortified from a bare perusal of clause 34 of the GCC, page 54 of the writ petition. It is stated that clause 36 of GCC at page 54 enumerates the situations in the eventuality the bidder or the contractor submits forged documents. These are part of the contract agreement. It may be stated herein that clause 36 of general conditions of contract is one of the annexures of the tender document issued to the bidder for their knowledge regarding terms and conditions of prospective contract with ONGC at the time of bidding. After award of contract, the same GCC becomes main contract document. Hence, the word bidder is used broadly in this clause, referring to bidder at the time of tendering and also to the contractor after award of contract. This becomes further clear from the usage of the words forged documents, certificates, information towards fulfillment of any of the tender contract conditions. In the said clause 36, it is pertinent to mention herein that these are the standard clauses of ONGC and is present in all service contracts of ONGC, and petitioners having worked with ONGC since last several decades must be aware of the same. It is pertinent to mention herein that the integrity pact annexed at page 1058 of the writ petition
is issued to the bidders during the tendering stage, and the signed integrity pact is to be submitted by each bidder as it becomes part of the contract with successful bidder. For ease of reference, the relevant clauses of integrity pact are quoted herein below. So we have quoted this. Now coming to page 183 after the quoting is over. It is stated herein that a perusal of the aforementioned clauses of the integrity pact would fortify the fact that there exist provisions in the contract for disqualification of bidder from a tendering process or termination of contract or banning for a maximum period of 3 years. It is stated herein that the order dated 9/1/2024 issued for banning the petitioner number 1 for a period of 1 year has been carried out within the ambits and terms and conditions of the contract agreement. Very clearly we have stated in respect of integrity. It is pertinent to mention here the petitioner 1 has not only been banned for 1 year, although there is a provision, so has only been banned for a period of 1 year, although there is a provision of banning for a period up to 3 years as per the contract agreement. So it is not that something alien we have imported. This integrated practice, their lordship. Apart from that, the guidelines and the manual. Its only good position was because lordship that the contract period was ending. So the facts are more or less over, lordship. My humble submission is that there is no flaw either in the so cause notice, though no flaw either in the decision-making process, no flaw in the impugned order. Impugned order, we have not indicated any provisions, but all the provisions are there. That means the source of power is there. We are disclosing this before in these writ petitions. We are not hiding anything. And in support of this lordship, I would like to refer to 2-3 judgments. So as they are not arguing, I'm not showing this judgment regarding personal hearing, because personal hearing, they are not arguing, although it is a pleaded case. So I brought some judgments. I'm skipping this. Regarding the fraud, 2005, 7 SCC, page 605. Bhaurao Dattu Padalkar versus State of Maharashtra. Here, detailed elaboration is there regarding fraud from paragraph 9, 10, 11 up to 12. Up to 16, lordship.
Up to 16.
Yes, from 9 to 11. But I just read only one paragraph. 11. Then, a fraud is an act of deliberate deception with a design of securing something by taking unfair advantage of another. It is a deception in order to gain by another's loss. It is a cheating intended to get an advantage. Here, that advantage is to get benefit of the contractual obligations. They must have the group insurance throughout the 3 years period. So there was a gap. They failed to renew it on time at the end of the 2 year. And their officer have done it 1 month later. That interim period of 31 days, lordship. They failed.
What benefit will they get?
They get benefit, lordship.
That
Now-
money, the money benefit.
No, because they have to secure the life and the injury and etc. of their employees. Had it been a suppose there is a major incident. So we have, just like we take the third party vehicle insurance. For my injury, I can take, but for the third party's injury. So their company have to take care of all the employees who are employed. These are highly hazardous works, lordship. So that is why this is a very strict condition in our contract agreement. 11. Fraud, as is well known, vitiates every solemn act. This is what I am trying to emphasize, lordship. So once fraud is done, we can forget about all the terms and conditions of the contract agreement. Whether there is a word of banning or not banning is there. Any person with reasonable logic will say that this is a very minor punishment they are getting. Some persons should have gone behind the bar for 7 to 10 years for this kind of fraud. This is a very minor steps taken by ONGC in my humble submission. Very lenient. We should have act very hard so that in future, nobody would have dared to do this kind of mischievous act with a public sector undertaking. It is not a issue between two brothers. So this judgment. So others, Lordship, regarding so-cause notice, they are not challenging the so-cause notice. We have given the, whatever we have to indicate in the so-cause notice, we have done everything. So in that case, Lordship, I would like to give this judgment. What are the requisites in a so-cause notice, Lordship? Yes. 1975, 1 SCC page 70. I think my learned friend also relied upon this. Paragraph. Yeah. Paragraph likha tha na? Paragraph 18, if I am not wrong. Yes. Paragraph 18.
One has relied on para 17, you are relying on para 18.
Yes. My Lord Justice Selamisters judgment, Lordship of Authority. So we have indicated that what proposed action we are taking, what are the allegations we are taking, and we have given reasonable opportunity of defending. They have submitted to that so-called notice. They have not challenged. They could have challenged at that point of time. That has gone. If there is any flaw. There was no flaw. Therefore, Lordship, they participated in the inquiry process. They could have challenged the appointment of the inquiry officer. They could have asked for many other things. They have not done. They themselves have said, yes, we have done it. A small mistake they have said. It has been done by one of the officers. His apology letter has also been furnished. We would have understood that if they have filed a FIR against him. And I'm unhappy because that company also have not done anything. That insurance company, their document has been frauded. In any case, Lordship, paragraph 18 here. Thus, there is no disputable requirement so-called. We may hasten to add that once the so-called notice is given, an opportunity of reply of the so-called is afforded. It is not even necessary to give a oral hearing. So oral hearing also, in fact, they came with their full team and submitted the documents. If they had asked for oral hearing, Lordship, we would have, because it is an open case of documentary evidence. So this is my humble submission. There is absolutely no infirmity, illegality, arbitrariness on our part, Lordship. Whatever is permissible under the rules and regulations we have done, we have given full opportunities as per the requirements of principles of natural justice. And therefore, in that view of the matter, this writ petition deserves dismissal. I'll take 10 minutes for a short reply at 2 o'clock.
Only one question, whether section 3 bars the respondents from issuing the blacklisting order.
In my respectful submission, it does. And section 3 has further requirements. That is why I placed the entire section 3 when I placed the integrity factor.
You see, that is the long and short of this case. It all depends on section 3, whether they can do it under section 3 or not. Because otherwise,
I'll address each of
the facts are all clear.
the facts are clear.
You have
That's why
admitted,
my
inquiry report also not required because we admitted fact. There is no prejudice will be found. So only on the section 3.
No, prejudice aspect, there are vital issues. I'll address it. I'll take at best 10 minutes, one at 2 o'clock. So my colleague will be here.
Yes.
The integrity fact
Now,
and that IMF. Now,
leave aside IM, let's go to that integrity fact.
both, I'll deal with both simultaneously. There is what is the logic? Why does the termination clause say that after expiry of the period of the contract, you cannot blacklist? Expressly
Where does it say?
in clause 18.6,
Acha, 18%, there is this page.
page 44. (18.6) second paragraph. In case of termination of contract herein set forth, except under 18.1, and 18.2. The logic is 18.1 is termination on expiry of the contract. So once the contract period has expired, you cannot cannot blacklist. The logic is very simple. The logic is there is no relationship between the employer and the contractor anymore. There is no subsisting relationship. It is like me saying that I am blacklisting one Mr. X, where I do not have any relationship with it. There is no privity of contract anymore. So therefore, you cannot simply borrow the provisions in the Integrity Pact or clause 17 of the IMM to say that we can fall back on this. So who are you? What is your locus? What is your jurisdiction? What is your authority? There is no relationship that subsists. When, and your lordship is aware, an act without jurisdiction is a nullity. It's void ab initio. And therefore, being conscious, they had included this clause at clause 18.
That is with regard to termination. Termination.
No. Clause 18.6 also talks about blacklisting as a consequence of termination. The logic, that is why I'm going to the very root of the matter. They say that except 18.1 and 18.2, if someone is terminated under 18.3 to 18.5, he can also be blacklisted. Because that will be during the subsistence of the contract and there will be a relationship if it is on account of 18.3, 18.4 or 18.5. But as soon as it expires, there is no relationship that remains. That is the first logic. And going by that logic, neither will the Integrity Pact Section 3 be applicable, nor will 17 be applicable. And now let us come back to the Integrity Pact itself. Your lordship will, that is why this sequence of events is also very important. If your lordship will kindly come to 108. Integrity Pact. The ONGC is banking on these three words in any other form.
Yes.
Let us read this once again. If the bidder, before the contract award, has committed a transgression through a violation of Section 2 or in any other form, such as to put his reliability and credibility as bidder into question, the principal is entitled to disqualify the bidder from the tender process or to terminate the contract if already signed for such reason. If your lordship reads the whole clause as a whole, your lordship will find that assuming someone has, because Section 2 pertains to the entirely to the tender process. Now, what it actually intends to do is, assuming he has committed, some bidder has committed some transgression during the tender process, but inadvertently that was overlooked, but the agreement has got signed. So in that case, his tender cannot be rejected because the agreement has already been signed. In that case, it can be terminated. It cannot take it beyond the expiry of the contract in any manner. If your lordship reads the whole clause, and even there, they are qualifying it by saying what? You will take note of the severity of the transgression. You will take note of the extent of the transgression. And then at clause 2, they say that there has to be available evidence without any reasonable doubt possible.
There is no doubt here.
No, that is where.
With regard to the facts of the case, there is no doubt.
No, that is why I'm coming to the other aspect. Now, one of the submissions advanced was in the show cause notice, we did not mention the Integrity Pact. We did not mention 17.1. And therefore, however, since the fact is admitted, no prejudice is caused. No. What is the principle of, what is the logic behind the principle of natural justice? What does Eurasian equipment followed by Gurkha say? That each and every allegation and each and every contemplated action is to be set forth precisely. The language used in Gurkha, paragraph 17, is precise.
But when you yourself have admitted.
No, that is why. If your lordship comes to the additional affidavit that was relied on by my learned friend. This is your lordship will also kindly note this. additional affidavit starts at page 214. It is an affidavit filed after filing of the counter affidavit. When they realize we filed our writ petition, they filed their counter affidavit, we filed our rejoinder. After that, they started getting wiser. They realized that they cannot invoke anything, they cannot invoke the integrity pact. That is why.
But AG was saying they have invoked integrity pact.
That is why I would like to take your lordship back to that additional affidavit. If your lordship will kindly come to that additional affidavit at 214.
Yes.
And your lordship will turn to paragraph 4.
4.
Yes. That the answering respondent states that the inquiry officer on 30/10/23 duly submitted its inquiry report to the management of ONGC. In the said inquiry report, the inquiry officer concluded that the petitioner had committed a breach transgression of clause 17.5.1F of the IMM and the terms and conditions of the contract agreement by submitting manipulated, illegal, altered document during the execution of the agreement. There are two findings by the inquiry in the inquiry report, according to their affidavit. Number one is that there is a violation of 17.5 of IMM. And secondly, that there is this manipulated, now they want to further stretch it further to a fraudulent document. These are two aspects which have developed after the show cause notice. In the show cause notice, your lordship will not find any mention of forged document, and your lordship will not find any mention of clause 17.5. So therefore,
No, I think there is something with regard to forged document.
no, absolutely not. They are saying that the dates are different. They are not saying anywhere that you have submitted forged documents.
Yeah.
Your lordship will kindly come to the show cause notice at page 141.
You see, even in your reply at 143,
Yes,
if you go to the second paragraph,
yes.
you say that wherein we would like to mention that in your contract page number submission of forged documents.
This is
When this is clearly mentioned that forged documents, certificates, information, shall immediately reject.
my lord. It is in the context of clause 36. They are saying, if your lordship will first come to the show cause notice, my lord.
Yes.
In the second, in the very first paragraph, last sentence, your lordship will kindly note this sentence, with reference to contract clause number 30.
Page
141. This is the show cause notice.
yes.
Your lordship will kindly come to the last sentence of clause 1.
No, you come to paragraph 1.
Yes. You had submitted an insurance policy bearing number so and so,
Yes.
with collection date so and so, and policy date effective from so and so, and valid in so and so. Later on, you had submitted another insurance policy bearing the same number,
But with a different collection date.
right, valid up to so and so.
So that itself shows that there's a fabrication of the date.
No, my lord. That is why I would like to come back to the judgment placed by my learned friend. What is a fraudulent act? It has to be an act done for gaining some benefit. What benefit? Rather, I had to pay because there was a lapse of the insurance policy. I had to pay from my pocket to that employee. There has to be some financial benefit that has to accrue on account of the fraudulent activity. Now, if your lordship will kindly come to the last sentence, with reference to contract clause number 36, your lordship will kindly note this one. Clause number 36, of page 28, submission of forged documents. This is a violation of the terms and conditions of the agreement. This is the allegation. And in this context, we are responding at paragraph 1. And if your lordship sees clause 36 at page 54, we are trying to say that in response to the show cause notice, that clause 36 is not even applicable. Your lordship will kindly see clause 36 at page 54. Submission of forged document. Bidders should note that ONGC may verify authenticity of all the document certificate information submitted by the bidders against the tender. In case at any stage of tendering process or contract IPO execution stage, it is established that bidder has submitted forged document certificates information towards fulfillment of any of the tender conditions, ONGC shall immediately reject the bid of such bidders or cancel, terminate the contract. So during the tendering process, if I have submitted any false document, then the tender is liable to be rejected. Or if inadvertently the contract gets signed, it can be terminated. They referred to clause 36, and in response to their reference to clause 36, we are responding that clause 36 is not applicable. They never said that during the course of the contract, you have submitted a forced insurance policy, and that amounts to a fraudulent act, and that entails blacklisting. That allegation does not find place anywhere. Even after assuming
Where is the show cause notice again? Page?
page 141, there is a, it is in the context of the last sentence that we are responding, that this clause is not even applicable.
It is not with regard to that, with regard to that integrity pact.
Yes. And your lordship will find, interestingly, there is no mention of 17, even in the impugned order, either in the show cause notice. The reason is very simple. They inquire, that is why our allegation that you did not give us the report may have a lot of substance, because it is for the first time at the stage of submission of the report that the inquiry officer says, because he perhaps realizes that clause 18 is not applicable, integrity pact is not applicable. So therefore, the only thing they can fall back is IMM. Had they put us to notice, now the submission that was advanced was that there is no prejudice cause. Had they given us an opportunity, how we could have responded. And that is why your lordships time and again say, while exercising jurisdiction under 226, that natural justice should not be used as a mere formality. It has to be an effective opportunity.
Okay, I think
Your lordship will kindly come to their
you have taken 15 minutes.
I'll just
I've
quickly.
got a lot of matters.
I'll just.
We have taken more than 1.5 hours earlier.
I'll
both of
just
you.
place one page, Bala, 244.
Last, no.
No further. I won't trouble you a lot. Page 244 of their additional affidavit. Who is it that they can remove from? Because there has to be a privity of contract. 17.5.1, removal from the approved list. The name of the contractor may be removed. I am no longer a contractor after 9/11/23. The relationship has extinguished. So it is a contractor who can be. Therefore, and if your lordship sees the contract itself, page one last document, Manu, your lordship will just quickly take up page 28 of the writ petition. What
Yes.
is it that will govern the relationship? Is that page 28 of the writ petition, subclause B?
Yes.
This chart does not include that IMM. These are the documents that will govern the relationship between the petitioner and the ONG. Your lordship will not find any mention of any IMM. So therefore, in my respectful submission, Manu, looked at from any angle, and particularly going by the principles laid down in Gurkha and Kulja,
Okay,
this
right.
has to go.
Anything else?
No.
Heard Mr. I. Chaudhary, learned senior counsel. For the petitioner, assisted by Mr. K.P. Pathak. Also heard Mr. D. Saike, learned senior counsel for the respondent ONGC, assisted by Mr. Annexing. Annexing. The petitioner is aggrieved by the impugned order page
Impugned order is at
dated
page
9/1/2024,
149.
issued by the ONGC.
I'm sorry to interrupt, Manu. Can my presence be excused? My friend will be. Obliged.
By which the petitioner has been banned from having any further business dealings with the ONGC in any capacity or participating in future tenders of the ONGC for a period of 1 year. That is till 8/1/2025. The petitioner's case is that the contract agreement, no, the petitioner's case is that the petitioners were awarded the contract work for operation and maintenance of gas compression services at South Banskandi, BNSKNDI, in the district of Kachar. White contract bearing number 901-003-0760, dated 16/10/2019, for a period of 3 years. Which was extended till 9/11/2023. An agreement was executed between the parties on 16/10/2019. And in terms of the said agreement, the termination of contract of the contractor entailed the blacklisting of the contractor in terms of clause 18 of the contract agreement. Further, in terms of the integrity pact, which was part and parcel of the contract agreement, sections 2 and 3 of the said integrity pact. Was it a part of the contract agreement? Section 2 and 3 provided the manner in which a contractor could be disqualified from the tender process and from being excluded from any future contracts of the ONG. The petitioner's counsel submits that the contract was completed, the contract between the parties expired on Nine 2023, when the work was completed. While the impugned order dated 9/1/24, blacklisting the petitioner was issued two months later. The petitioner's counsel submits that in view of the above, it submits that in view of there being no privity of contract between the parties as on 9/1/2024, the state response, the ONGC could not have issued any order blacklisting the petitioner for a period of 1 year, either in terms of clause 18 of the contract agreement or under the integrity pact. In terms of clause 2, section 2 and 3 of the integrity pact. Next para. The learned senior counsel for the subjects that the show cause notice dated 5/10/2023 issued to the petitioner was only with reference to clause number 36 of the contract agreement executed between the parties, and there was no mention of either clause 18 or the integrity pact in the show cause notice. As such, when the petitioner has not been put to notice with regard to the intention of the ONGC to blacklist the petitioner in terms of either clause 18 of the contract agreement or section 3, section 2 and 3 of the integrity pact, the impugned order blacklisting the petitioner was not sustainable and had to be set aside. In this respect, he has relied upon the judgments of the Supreme Court in the case of Dash versus Dash, reported in 1975, 1 SCC 70, 2014, 9 SCC 105, and 2014, 14 SCC 731. Next paragraph. The learned senior counsel for the ONGC, on the other hand, submits that even though clause 18 of the contract agreement executed between the parties is not applicable to the case in hand, there was no infirmity in blacklisting the petitioner in terms of section 3, section 2 and 3. In section 3, not 2 and 3. Don't cut. In section 3 of the integrity pact. He submits that when there is no dispute with regard to the fact that there had been a manipulation of dates in the insurance certificate issued by the insurance company by an employee of the petitioner, the petitioner being vicariously liable for the acts of his employees, the fraud committed by the petitioner came within the provisions of section 3 of the integrity pact. He also submits that though the petitioner has made a claim that the inquiry report made by the ONGC had not been furnished to the petitioner, the same could not have caused any prejudice to the petitioner, as there was no denial of the fact that there had been a fabrication of the dates in the insurance certificate by an employee of the ONGC. Correct? Next para. The learned senior counsel for the ONGC submits that the action of the respondent, petitioner, in manipulating the dates in the insurance certificate was in violation of clause 17.5.1 of the Integrated Material Management Manual bracket IMMM of the ONGC. Full stop. As such, when there is no denial of the fact that there has been a breach of clause 17.5.1 MMM, which provides that the contractor may be removed from the list of contractors by the ONGC, if the contractor has indulged in any type of forgery or falsification of records, the blacklisting of the petitioner by the ONGC. Was in terms of the integrity pact provided in the contract agreement. He submits that in view of there being a fraud being committed by the petitioner in the insurance certificate, which was to cover the employees of the petitioner during the contract period. And as no notice was required to be given to the petitioner with regard to the, just give me that, I think, 1975. Yes. No, and as the state can impose reasonable conditions. He was talking about section 18. How does this Eurasian equipment, paragraph 18, that's what you're relying upon, correct? Huh? You're relying upon Eurasian equipment, 1975, 1 SEC, correct? Para 18. Yes. How does it help your case? Huh? How does it help your case? No, and as the state can impose reasonable. Huh? Huh?
That is regarding the serving of requirement for serving the SOCOS.
Yes. So how, which paragraph? There's nothing here.
Not.
Yes, sir. And as the state can impose reasonable conditions regarding rejection and acceptance of bids or qualifications of bidders. He has relied upon the judgment of the Supreme Court in the case of in the case of 2005 7 SEC 605 and 1975 1 SEC 170 respectively. He accordingly submits that there be no infirmity with the blacklisting of the petitioners, blacklisting of the petitioner due to the act of fraud being played by the petitioner during the subsistence of his contract, comma, the writ petition should be dismissed. Next, I think that's all. One more.
One submission that we had made, that the IMM, which they are relying upon, that is not a part of the contract agreement, as per page number 28. It only was
Okay,
referred to
that's
for the
right. One
first time
thing,
in
the
the inquiry.
petitioner's counsel further submits that the inquiry report on the basis of which the petitioner has been blacklisted has been made on the basis of 17.5.1 of the IEEE, comma, which is not a part of the documents which is to be considered to form a part of the contract agreement executed between the parties. Huh? Okay, then next, I have heard the counts for the parties. Hearing concluded, judgment reserved. I can do it, but there's no time for the others.
Give you that.
Yes, you have admitted the amount.
Yes, madam. We have filed an affidavit.
Huh?
We have already filed affidavit.
You have filed, have you paid? No.
No, madam.
You have only admitted the amount.
Yes, madam.
Uh-huh. Heard, Mr.
AK Rai.
A.K. Rai, learned counsel for the petitioner who submits that in pursuance to a tender for supply of office stationeries and miscellaneous articles and equipment under the Directorate of Social Welfare, Assam, and its district / subordinate offices, the petitioner supplied articles / materials / equipment amounting to rupees 7,55, 66, 962. However, the request of the petitioner for release of the outstanding bill amounts have not been paid. Bill amount has not been paid by the petitioner till date. Acha, Mr. A.K. Rai for the petitioner, Mr. M. Chetia for the respondent. Next. Mr. M. Chetia, learned counsel for all the respondents, submits that that though the petitioner is liable to be paid the amount claimed by him, the same has not been made due to non-availability of funds. So he submits that though proposals for sanction of the amount have been made to the state government. No sanction order has been received from the government till date. Full stop. I have heard the learned causes for the parties. Para 3, 4, para
Four and five.
3, 4 and 5 of the affidavit in a position filed by the Joint Director, Women and Child Development, Assam. Is to the is to the following effect. The next para. Para 1 of the affidavit of the respondent number 4, that is the Joint Director, Women and Child Development, Assam, also states that the Director, Women and Child Development, Assam, has authorized the respondent number 4 to file this affidavit, to file the above affidavit on behalf of the respondent number 2 also. As can be seen from the documents on record, the petitioner had been given various supply orders from the year 2014 till
5 to 15 till 12/12/2020.
till the year 2020.
So we have supplied, there was a first initial order and generally we've supplied because miscellaneous.
I have been from 2014 till 2020 for supply of various stationery articles. However, no payment has been made by the state respondent for a long period of time. The government has only been making orders for supply of stationery articles without appearing to have made any funds available for payment of the supplied articles. The manner in which the state government has been denying payment to the petitioner while taking articles from the petitioner, stationery articles from the petitioner, is blatantly wrong and unfair. As the respondents have categorically admitted to the fact that they owe the petitioner the amount of rupees so and so, this court directs the respondents to make available the funds and to pay the petitioner the said amount within a period of, it's nearly 8 crores, how much? Again,
3 months.
it won't happen. See, within a period of, today now is October, no? March ending will be better.
And in the month of September, they paid for 5 months time. Within 5 months.
Within a period of 4 months, so that 4 months.
Develop.
from the date of receipt of a certified copy of the report. Read petitions accordingly to accordingly allowed. Yes,
Right, Your Lordship. Your Lordship, I pray that your Lordship will see the order dated 8/10/2024 by this court.
yes. Who's appearing for the other side?
Central Government Standing Council are appearing.
Yes, who is appearing?
Today, gentlemen, I will verify person. Otherwise, I will verify this.
It's a very simple matter. He wants extension. His period is ending on 16th December. So this court on 8/10 had directed that the additional director shall consider the representation and pass a speaking order in terms of clause 6. That's all. It's only to pass a speaking order.
Malad,
But there has been another advertisement.
another advertisement, which also is there in the writ petition, my lord. Subsequently, when it is existing, without any modification or cancellation of that or that tender order, a fresh tender is again issued, my lord.
Anyway, but yes. So another thing is that why do you want to? Another thing is that now his contract is ending in December. Yeah, we issued another advertisement for contract. Why can't he carry on?
Today I indicate procedure because the matter was related to the particular.
My lord, I pray
Lordship may
that your
fix-
lordship will come to page 27.
Lordship
of
may
my
then day after tomorrow, Lordship may fix it on the witness the Lordship. In the meantime, I will inform the.
Okay, you get information by the next day.
Lordship.
My lord, maybe fix on 26, my lord.
Okay, on the prayer of 26 is Saturday.
No, sir, no, my lord, it is Friday. Oh, it is Friday.
25th is Friday.
Oh, sorry, sir, 25th of.
On the prayer of the petitioner's counsel, this is the matter on Friday. In the meantime, Mr. K. Gogoi shall obtain instructions as to whether a speaking order has been passed on the petitioner's representation for extension of his contractual service.
Whether the speaking order is already there before your lordship,
Is there?
speaking order is there before your lordship, but then the speaking order is.
How
not-
can it be before me?
No, that, the lordship wanted a copy of it, Milan.
Oh, there is a speaking order has been issued.
Yeah, it is issued, Milan, your lordship wanted to see it,
Okay, this
but
one.
then, lordship may come directly to page number 2, clause D.
Yeah,
Contact cannot be ordinarily after it is over. Milan, it will be more clear if a lordship comes to page 27 of my petition. Page 27 of my petition, Milan, that will be more clear. Page 27 of my petition, Milan.
yes.
Clause 12, Milan, period of contact, may I read, Milan?
Ah,
The contract shall initially be for a period of 3 years from the date of signing the contract. The contract is not extendable ordinarily after it is over. That means after contract is over,
so it should be for 3 years.
yes, Milan.
Did
But
you
the-
sign any contract
no,
agreement?
but then, my lord, extension provision is there, my lord, the second clause, my lord. However, the contract may be extended for 1 more year on the same terms and conditions of the contract, strictly on the basis of satisfactory performance at the sole discretion of additional.
Okay,
directors.
so one thing is this.
Fine.
But your 3 years is going to end on December.
On 16th of December.
So now you've got to challenge this then. It is their discretion. You've got to challenge this.
No, but
Now it's a different cause of action.
My
It
lord,
is- it-
yes, my lord, then your lordship will have in merit, my lord.
No. Have you put this to challenge?
No, that is why, my lord, today, yesterday we have got it. And that's why we prayed your lordship that we may be allowed to bring the subsequent events before your lordship so that the matter can be finally disposed.
Then you have to amend the writ petition. You see, you cannot make an oral prayer.
No,
If you want to challenge this, you have
no,
to amend the
we
writ
may want to
petition.
file, Milord.
Huh?
My prayer is that we may be allowed to file this new petition so that we can bring the subsequent events before your lordship to take up the matter on merit.
Not to, this is a completely new cause of action.
Yes, Milord, we'll bring all these.
No, you have to file it cannot be done, Mr. Counsel.
No,
Your main case cannot be in your affidavit in reply. Your main case will have to be in your writ petition.
No, definitely we are filing a writ petition on that count. If a
Huh?
lordship is, that we'll file a fresh writ petition then.
Better, because so this writ petition has become infructuous. That's what I'm saying. This writ petition has become infructuous.
But then all the documents and instruments which are related directly to the same contract. That is why I said that we may be allowed to file a writ petition, fresh writ petition, bringing the subsequent developments.
Mr. Counsel, you see this case,
Yes.
if you're going to file a writ petition, this case is infructuous. This is what you have got to challenge. You see, you have been given a contract period for 3 years, which is extendable by 1 year, provided that they agree.
Yes,
Your 3 years going to end,
yes.
and you have asked for extension for 1 year. They have rejected your application.
But then that rejection was not proper. That is why I said.
That is why please challenge it in a fresh writ petition. Please close this writ petition. This has become redundant.
All right, Milord.
That's what I'm saying. This has become redundant. If you file a fresh writ petition, challenge this. And
There are also as per clause 12 laws.
that's what, prayer has been, the prayer has been answered.
But
Then
then
that-
not appropriately, Milord. It has to be.
Maybe not
happened-
appropriately, that's why you've got to challenge in a fresh writ petition.
All right, Milord.
I heard Dr. C.R.C. Bopatra Gohain, Learned Senior Counsel. For the petitioner, assisted by Miss P. Hazarika. Also heard Mr. K. Gogoi appearing for
All the respondents.
all the respondents. The petitioner's counsel submits that the present writ petition has become infructuous in view of the order dated. In view of the order dated 18/10/2024. He accordingly submits that the petitioner will be filing a fresh writ petition challenging the order dated 18/10/2024. Full stop. That's right, huh? The petitioner's case is that he is having an existing contract as an authorized local chemist under the Central Government Health Service till 16/12/2024. The further case of the petitioner is that in terms of where is that clause page?
Clause 12, Milord.
Page.
Page 27.
27 laws.
Further case is that in terms of page 27.
27 laws.
Page 27.
In
clause
terms of clause 12 of the
Contract agreement.
contract agreement executed between the parties, comma. The initial contract is for a period of 3 years, which may be extended for 1 more year. Strictly on the basis of satisfactory performance, comma, at the sole discretion of the additional director CGHS, comma, Guwahati, comma, with the approval of the ministry. The petitioner accordingly submitted a representation dated 23/9/2024, requesting for extension of the contract in terms of clause 12.
Only 1 point.
Full stop. As the petitioner's representation was not being decided, the present writ petition was filed. Full stop. Next paragraph. During the pendency of the writ petition and on the basis of the order dated 8/10/2010 passed. No, don't say that. I said this court, in its order dated 8/10/2024, directed the additional director of Central Government Health Service Scheme, Guwahati, to consider the petitioner's representation and to pass a speaking order in terms of clause 12 of the contract agreement. Full stop. Dr. R.C. Borapatra Gohain submits that the additional director CGHS Guwahati has issued order dated 18/10/2024, regretting the petitioner's representation to extend his services by 1 more year. He accordingly submits that as the present writ petition has become infructuous, the petitioner will be filing a fresh writ petition challenging the order dated 18/10/2024 issued by the additional director CGHS Guwahati. Full stop. In view of the fact that
if a lordship comes to page 63 of my petition, and they are saying about satisfactory performance, 2 of the certificates are provided by their
Mr. Counsel, that will be in a different writ petition. Your prayer here
Yeah.
is that clause 12 should be followed.
Yes.
Clause 12 has been followed. It
Yeah.
has been followed. Now you are not happy with the final decision. You have to make a separate challenge.
My lord, new GEM is also issued on 4/10/2024, my lord.
Mr. Counsel, please understand. You have to file a fresh writ petition to challenge this. Your prayer has already been answered. Your prayer in this writ petition, that your representation should be decided as per clause 12 has been decided. It's the end of the matter. Whether the decision is right or wrong, that you have to challenge in a fresh writ petition. Right, in view of the order dated 18/10/2024, passed by this court finds that the present writ petition has become infructuous. The writ petition is accordingly dismissed as infructuous. It is accordingly closed as infructuous. I've given you, I've said that you have already made your representation. You fight. Admission. Where's the affidavit?
My lord, we have filed our affidavit, my lord,
When?
on 9/9/24, my lord,
9/9.
by respondent number 2.
I'm appearing for respondent number 4, your lordship. I have received my instructions.
So basically, my lord, here we have admitted, my lord, it is PWD.
Have you got the affidavit?
Yes, my lord.
Affidavit filed by respondent number 2.
Respondent number 2, my lord.
Oh.
One Abdul Mutin Choudhury.
So 1,94 lakhs.
My lord.
Part payment, outstanding amount is 1,11 lakhs.
1/4/11.
Correct?
Correct.
And out here? I don't know what is happening.
Basically, my lord, we were, PWD were, my lord, here was the executing body, my lord. We built, my lord, the building for the education department, my lord. So we have content, my lord,
So who has to pay the amount?
my lord, we have asked for the money to them. We have sent a demand
To whom?
to the education department.
So all of you pay.
My lord, education, unless education gives the money to us, we cannot, this building is not cost. We are like this, machine man. We just has built it.
Anyway, all of you all pay.
So my lord, my lord will take into consideration my affidavits para 8.
Correct.
In para 8, we have stated, my lord, that we have admitted.
You are for whom? You are the other?
For your lordship, at the secondary.
Shall we ask them to file affidavit or this letter is enough? I think.
Yeah, that's fine. May I submit one thing, ma'am? I have handed over the completed work in the year 2019, my lord.
So,
So interest may be enforced.
Yes.
Not in a writ.
Civil court, my lord.
sorry. Not in a writ petition,
Yes, your lordship.
right?
Even Tamsarali did not, my lord, give that interest.
Correct. 2018. And when did you come to this court?
24, my lord, 3 years, my lord.
Limitation Act,
Beyond limitation.
then be happy. Now you don't have to worry. Heard, Mr.
Yes, Halim.
S. Ali, Learned Counsel for the petitioner. Also heard Mr. Ardhar. Ardhar for
My lord, for PWD, my lord.
the PWD. While Miss
H. Terangpi, your lordship.
Huh?
H. Terangpi.
H. Terangpi appears for
Respondent number 4.
respondent number 4. The petitioner's case is that despite having completed the work, completed the construction work for infrastructure development of bracket number 1, Bag Mibor Nilomoni Pukan HS School. Number 2, Victoria Girls HS School. And number 3, ART High School at Margarita. Correct?
Yes, but
Under the NEC funded projects. The petitioner has not been paid. His contractual dues, balance contractual dues amounting to rupees 1, 11, 99, 655. Next para. Mr. Ardhar, Learned Counsel for the PWD, and Ms. Swenso for the respondent number 4, submit that the state respondents admit that the petitioner is still to be paid rupees 1, 11, 99, 655. Full stop. Next para. Mr. Ardhar, Learned Counsel for the PWD, submit that the PWD was only the supervising authority.
Executing, my lord, we have built that.
It was the supervising and executing authority. Full stop. The funds for payment of the outstanding dues of the petitioner has, however, to be made by the
Director of Secondary Education.
Director of Secondary Education, Assam. Full stop. I have heard the learned counsel for the parties. Para 5 and 8 of the affidavit in a position filed by the
Respondent number 2, Chief Engineer.
respondent number 2, Chief Engineer, PWD, bracket, border roads and NEC work is to the following effect. Next. The counsel for the respondent number 4 has submitted letter number E-545-366/46 dated okay, no date.
Sign, my lord. 24, that is. 22. You sign, my lord.
Huh?
You sign. Electronic sign, but
He signed, but what is the date?
date hasn't been reflected, my lord. Memo number is there.
Okay, I have submit letter number so and so, huh? Letter number so and so. Issued by the Director of Secondary Education, Assam. Addressed to the Senior Standing Council, Department of School Education, Guwahati High Court. Which states that, which shows that the petitioner is still to be paid rupees 1,11,999,655.
So the last paragraph,
Huh?
the last paragraph.
However, the same could not be paid to the petitioner due to non-receipt of a revised administrative approval from the government. Further, the project was declared as closed as is where is basis. Huh? No, did you say further? No, the letter further states that the Northeastern Council Secretariat, Shillong, White Office Memorandum dated 8/1/2018 stated that the project is hereby declared as closed as is where is basis. You know, comma. When did you complete the building?
2019, my lord.
When? Okay.
In the month of June, my lord. Kindly come to pay.
I think they should submit an affidavit. What? This letter is incomplete, madam.
Let one let education file an affidavit.
Huh?
Let education file an affidavit.
Oh, okay. Full stop. And the next para, the council for the respondent number 4 shall file the letter, shall submit the letter number E-5453666/42 in terms of an affidavit. By way of an affidavit. Huh? Within, why 2 weeks? Within 10 days. Within 10 days. This is the matter after 10 days. Write everything, huh? Whatever is there, no problem. Huh? Give a date and in the month, the new month. 8.
Time being 22.
Lordship, here I'm appearing for the health department. Lordship, it matter pertains to non-payment of contractual bill.
So,
Lordship, here we have received incomplete instruction, Lordship. 1 week's time may be granted, Lordship, to get an exact assessment of the situation, Lordship. Initially, there was a confusion.
yeah, for whom?
I'm appearing for the health department, Lordship.
Mr.
A. Charlie, Lordship.
A. Charlie has granted a further
1 week's time, Lordship.
1 week's time to obtain instructions. This is the matter after a week.
Date kindly be fixed, madam. Otherwise, I'm on this date virtually, my lord. So much.
Fourth, my lord.
Yes.
In this case, they have not filed, neither they have filed affidavit, nor they have been passed any speaking order. This is the implement issue. Nothing new incumbent has been implicated, some notice has been issued, he has not yet appeared. Now they have also.
Learned advocates entered appearance for respondent number 3
Yes.
by filing Wakalat number. Who is the advocate?
Mr. Pinayak is there.
Huh?
Mr. Pinayak is there.
Mr. Nayak, yeah, here. Yes, yes.
Waiting for respondent number 1, Lordship. AGOL.
Three also.
Mr. Devajit Saikia, senior advocate. P. Nayak, or what? Yeah.
1, I think,
Huh?
or respondent number 1.
For respondent number 3,
The cost list, it is showing that respondent
please see.
Pinayak. It should be Pinayak.
Yes, Lordship. 3.
So,
So I'll have to obtain the instruction from the new incumbent.
how much time?
Lordship will grant it in this time.
22. Okay, Mr. P. Nayak appearing for the respondent number 3. Is granted 2 weeks time to obtain instructions.
3 weeks.
Huh?
3.
For, yes. Appearing for respondent number 3
Yes, Lord. Vocal number.
is granted 2 weeks, 3 weeks time to obtain instructions. This is the matter. After 3 weeks.
29.
In item 29, they have.
I
filed-
think, huh? Yes, Miss Boro, yeah, for,
Lordship, this is regarding tax sanction order, Lordship.
huh?
Yet to receive the speaking order, Lordship,
They have filed affidavit.
You are appearing for whom?
for respondent number 2,
2.
Akashdeep.
Yes, sir.
How much time do you want?
2 weeks, Lordship.
But here they have already filed affidavit, madam. Yes,
Tax
madam.
sanction order,
Huh?
tax sanction order, Lordship.
Huh?
Tax sanction order, Lordship. Some cases we have filed speaking order, Lordship. In this case, not filed, Lordship, not passed that speaking order.
The affidavit is passed
In
number.
other case of Fazlul Mannan, already filed, already passed speaking order. But in particular, content case, not filed, not passed.
So what to do?
We shall file, place the speaking order on next day, Lordship. Tax sanction order, really.
Miss R.B. Bora,
They already filed affidavit, but why this speaking order is necessary here?
page,
Page number 29, madam.
page number 29.
Yes, this is the affidavit in opposition. And accordingly, I have filed the affidavit in reply.
Page 29.
Page 29. This is the-
Affidavit of respondent of Anurag Goel. He's respondent number 2.
One.
One.
Now 2 has not filed. They have already taken stand, my lord, in this case.
I'm appearing for 2 Lordship here.
Huh?
I'm appearing for 2 Lordship.
Mr. Pinayak is for respondent number 1.
One has filed affidavit, Lordship. I'm
Ah.
appearing for 2 Lordship.
What is to be done here?
Lordships, a similar case, Lordship, item number 32, their speaking order has been passed. The same,
So when are you passing the speaking order?
Lordship, I shall I have already informed Lordship, whether they have passed or not, I need to verify. Lordship.
Okay, Miss R.B.
They-
Bora,
Madam-
counsel for the respondent number 2 is granted 3 weeks time to obtain instructions. This is the matter after 3 weeks.
But they are saying now this is the sanction order is fact, my lord. However, they have issued the administrative approval, technical sanction and work order in the year of 2016. Thereafter, they have filed FIR in the year of 2021. Now they are saying these all are have to file this speaking order.
Lordship, but
So that-
we cannot shoulder the burden where the sanction order is fake, Lordship.
Then
Let, let the speaking.
why they have allowed us to execute the work, but we have.
Why have you done, asked them to spend money?
Lordship, can we,
Have you taken any action against those persons who issued the order?
oh yes, Lordship, we have filed FIR, Lordship.
FIR, what has been done? When was the FIR filed?
CM Vigilance is.
When was the FIR filed?
Cooperating with them.
Nothing will happen. It's just name looks Big sounding names.
Let it be after 2 weeks.
Okay, after 2 weeks, list the matter 2 weeks. 2 weeks time is granted, list the matter. This is the,
32.
yes,
Yes, I have filed everything in July, but it's not a record. After 1 week. Okay.
correct. Petitioners council submits that affidavit in reply has been filed on,
Today.
has been filed today. To sub, registry to place the same on record, list the matter after 2 weeks.
Lordship, as per the office note dated 25/17/2024, the service has been completed upon the content number
True.
2. But Lordship, he has been already been transferred, Lordship.
Already transferred, then what to do?
Lordship, we need some time to file
Okay,
implement, Lordship.
okay, right. Mr.
D. Burman, Lordship.
D. Burman,
Yes, Lordship.
appearing for the petitioner submits that though notice was deemed to be served upon the respondent number 2, in terms of office order dated 25/07/2024, the respondent number 2 has been transferred out of office and another person has taken his place. Full stop. Next paragraph. Office note dated 25/7/2024 for the states that there is no AD card or unserved notice from the respondent number 1 and 3. What to do?
Lordship, incumbent has been joined.
You have
Lordship,
to file application.
Yes,
You cannot.
before filing the implement petition, we'll have to serve a notice to them, Lordship,
No, no. You have to serve notice to whom?
before implementing them, Lordship.
No. No need. You file it. You file an application.
Yes, Lordship. Lordship, we need some time, Lordship.
Okay.
to file implement.
List this matter after 2 weeks.
Lordship, 4 weeks if possible.
4 weeks.
Yes, Lordship.
Right. On the prayer of the petitioner's counsel, list the matter after 4 weeks.
Deeply obliged, Lordship.
Mr. Toby speaking of the passwords.
What? Complied with?
Speaking of the passwords. Text section order.
So,
Let
What
me cross measure.
okay, right. Mr.
A borrow.
A. Boro appeals for the petitioner while Ms. R.B. Bora appeals for the respondent number 2. Ms. R.B. Bora has submitted an order dated 14/8/2024, issued by the Secretary BTC, wherein
Lordship, 14 August.
Huh? Issued on 14/8/2024 by the Secretary BTC. Wherein it has been stated that the impugned work order issued to the petitioner is found to be fraudulent, correct? Full stop. In view of the above order dated 14/8/2024, the present contempt petition stands closed. Okay, right. The letter dated, continue. The letter dated 14/8/2024 is made a part of the record and marked as Annexure X.
My lord, this is a restoration petition filed by the corporation, my lord, for a review petition, my lord, which was, my lord,
Have we served a copy on the other side?
my lord, notice has to be given, my lord.
Huh?
Without notice, we cannot, my lord. That is
Okay.
why, my lord. If you notify,
Okay,
we
right.
can-
This heard Mr. Ardha, learned counsel for the applicant, who pays for restoration of review petition number 138/2022, which had been dismissed for non-prosecution while order dated 2/2/2024. Issue notice returnable in 4 weeks. Applicant to take steps for service of notice upon the respondents.
We can even,
Huh?
for Dasni, we can give, my lord.
Um,
We will take both.
Within 3 days, huh? In addition to the above, the applicant is also allowed to serve notice by way of justice service upon the respondents. List the matter after 4 weeks.
42.
Yes, what has happened?
No, the here direction of the honorable court is to
Payment of dues.
verify and pay. They have verified, my lord, and found that that particular due is not, he is not entitled for that.
Okay. Right. No one appears for the petition on call. Mr. Dinath appears for whom? For the respondent.
For the response.
Number one or both?
One and
For the respondents? Mr.
yes.
He
for the
submits
respondent.
that on verification, it was found that the petitioner is not entitled to the contractual dues paid by him. Correct?
Yes,
In terms of the letter dated
7/6/2024
7/6/2024.
is a
No,
second-
no, it is, not 7/6, 9/7/2024.
9/7/24 and the other letter is also there. I have given two letters.
9/7, okay, just a minute. In terms of the letter dated 9/7/2024, issued by the Secretary to the Government of Assam,
Gotcha.
Food, Public Distribution and Consumer Affairs Department. And the letter dated 7/6/2024, issued by, I thought the same thing, huh? But, okay.
One by commissioner, he was earlier director. Now he is designated as commissioner and the other by the secretary of the department.
Acha. And the 7/6 is by the commissioner.
By the
Okay.
commissioner. of food.
Commissioner of Food Civil Supplies.
But the secretary's order, kindly see the second page. Second page, it starts with the dot, bullet point, number 1 and 2 in the second page. Here claim is 13,99,044.41. They said that as informed by the Commissioner of Food and Civil Supplies, legal methodology by letter dated 7/6/2024, Annexure 2, in conformity with the Honorable High Court order, court's order, the matter regarding payment of 13,99,441 to the petitioner was examined by the Commissioner, so and so, jointly by the Deputy Director, so and so. As observed by them, the petitioner, so and so, is not entitled for the amount. Then next paragraph, in this regard, proposal was submitted by DC, claiming the bill amount of rupees so and so, which was returned to the office of the Commissioner, Food, Public Distribution.
Where are you reading? Commissioner's letter, correct?
Secretary, number 9/7/2024. 9/7/24, second page.
Yes.
It starts with the bullet point dot. As informed by the Commissioner of Food, Civil Supply, Legal Methodology, Assam, while later dated 7/6/2024, Annexure within bracket 2, in conformity with the Honorable High Court order, the matter regarding payment of rupees 13,99,441 to the petitioner was examined by the Commissioner of Food, Civil Supply, Consumer Affairs, so and so. And as observed by them, the petitioner, Vedangi Printers and Stationer, is not entitled for the amount. In this regard, proposal so and so, it was also returned. So after that, it is they have said, and in 7.6 later also, kindly see the second last parameter. Kindly see the, it starts with serial number 3, madam. On receiving petition number so and so in connection with the order dated 22/11/2023 passed in WPC number 6696 of 2023 and another petition on the same date, that is 4/12/23 in connection with the order dated 24/11/23 passed in WPC number 6724 of 23, the matter regarding pending liability against the fund has been examined.
Okay, right. The next para. What have I said just before that? Full stop. The letters dated 9/7/24 issued by the Secretary to the Government of Assam, Food, Public Distribution and Consumer Affairs Department, dispose. And letter dated 7/6/2024 issued by the Commissioner, are made a part of the record and marked as annexure X and Y respectively.
But in respect of the other amount, 15,54,000, he filed another contempt case, Lordship has already disposed of that. I have a copy of the order, that order. 15 is already paid.
Right, huh? The above two letters clearly show that the respondents have taken a stand that the petitioner is not entitled to the amount of rupees 13,99,441 as claimed by him in WPC 6724/2023. As such, the present, as such, this court is of the view that the order dated 24/11/2023 passed in WPC 6724/2023 has been complied with, as a verification had to be made with regard to whether the petitioner was entitled to the amount of rupees 13,99,441. Next para. In respect of the petitioner's claim for another amount of rupees 15,54,935 in terms of the order dated 22/11/23 passed in WPC 6696 of 2023, this court finds that the said issue has already been put to a close in the order dated 3/10/2024 passed in contempt case bracket C 297 of 2024. The contempt petition is accordingly closed.
But the order copy which I have given, I have taken a printout in a rough paper. If necessary, I will give a specialist.
Which one? It's okay. It's okay.
Just for it.
Annexure X and Y, no, I said. Annexure X and Y respectively, no? Anyway, this petitioner is not appearing at all. From the very beginning also, this order was passed in his absence. I mean, for issuing of the notice in the contempt.
Yes.
Yes, who do you want to implead?
My lord,
Who?
State of Assam represented by the
State of Assam is already a party.
my lord, Revenue and Disaster Management Department.
Then you make a correction to your petition. This cannot be allowed like this. Your prayer is you see, it cannot be a revenue. This, look, Mr. Council, what you have got to do is, you have got to make this, the principal secretary of the government of Assam, Revenue and Disaster Management, the department, this poor party so. This should be respondent number 6. So that first line, the state of Assam represented by this has to go. Because state of Assam is already respondent number 1. You cannot have the state as 2 respondents. They are the same.
My lord, each and every department in the separate head, my lord.
Correct. Correct. But when you say state government,
Yes.
when you say the state of Assam,
Yes.
then it has to be represented by 1 secretary.
Yes.
Now what you're going to do is, respondent number 1 is already the state of Assam.
Yes.
Now, if you want the revenue department to be a party here, you cut that state of Assam represented by. Please,
In the earlier of the
you have made a mistake. You have to cut that first line. You have made a mistake.
My lord, in that situation, my lord, earlier occasion, I have filed another petition. In that, at that time, I write like this, the Revenue and Disaster Management Department.
No. You have got to make secretary to the government of Assam revenue. You cannot make revenue department just like that. In the revenue department,
My lord.
there will be secretary,
Yes, my lord.
there will be director. You see,
Yes.
but you see, as per the CPC,
Yes, my lord.
please read the CPC. CPC requires that a department has to be made a party through the secretary. That is the law, Mr. Councillor. That's the procedure. I mean,
My lord, that Revenue and Disaster Management is not party here, my lord. Earlier occasion, my lord.
Mr. Councillor, you're not understanding. How can I teach you if you don't understand the basics?
My lord, may I allow to correct this?
You have to file an amendment application. That earlier practice of allowing you to do by hand, that is now forbidden. Because it cannot be uploaded in the system. That's the problem. This has already been uploaded. Now we cannot change this. Unless you file an application, and application is allowed, then you can file a fresh application. Better you withdraw this, file a fresh one. Cut this part, that's all. Then look at their prayer. To allow the petitioner to implead the name of the person. What name of the person? Which person?
As mentioned in para 2, my lord. That is para 2, my lord.
How can a department be a person? And you cannot say name of the department. You just say implead so and so.
Yes, party.
Just cut that first line, that's all. Implead the principal secretary, government of Assam, revenue and disaster management, so and so, and respond number 6. That's enough. No need to put state of Assam. And your prayer also don't say name of the person. It's not the name of the person. Instead of this name of the person, you put principal secretary of the government of Assam, revenue disaster management. Simple thing. We would have allowed you to do it by hand, but it's not allowed anymore. We are stuck also. And this High Court has also issued a notification that all this has to be done by way of an application. That doing it by hand is not allowed. You withdraw, find a fresh, easier. Mr. K.U. Ahmed, learned counsel for the applicant, says that he may be allowed to withdraw the application with liberty to file a fresh. Praise allowed. The application is dismissed as withdrawn with liberty of speech.